And and aha. All right. Is our friend Lactoid here? We are just waiting on our friend Pisco. He'll be here momentarily. So we'll just be waiting on that. Uh, while we are doing that, how are you?
I'm doing great. How are you doing?
I'm doing fantastic. It's been
That's
a
awesome.
relatively chill day. Um, I got a nap, so that was really nice.
It's finally hot where I am, so I'm enjoying it.
Mm,
Quick question before we start,
sure.
because this is more of like a legal discussion. I have an opening that's like I know my openings are like a little bit lengthy. This one's like slightly longer. Is that okay? Just want
That's
to make sure that's
perfectly
okay.
fine. You're gonna be dealing with Pisco, right? Like in terms of a person who likes to speak, and goes on and on. Yeah, but you'll be
Sure.
in good company. So
Yeah, I just thought it'd be weird if like I give this long opening and then piece goes like 2 sentences. Like, yeah, I think it's okay. I think it's
yeah,
cool. I think.
2 sentences of Pisco. Okay. All right. I like if he gave me an opening like that, I'd be like, hey, is something wrong, buddy? Like, do you need to talk? Just stop the debate.
It's a tough industry, right? There's a lot of stresses.
uh, um, just randomly while we're still waiting, what got you into law in the first place?
Oh boy. So like many law students, really, and most college students, I didn't really know what I wanted to do. Went into undergrad, changed my major, and it was like a couple. I took an unpaid internship, actually, at the public defender's office, and that's what got me into it, right? Because I was interacting with people in the jail. I was, gathering information. I was reading up on certain cases, and I thought, this is something I can do. And well, I apparently did it well enough to graduate law school. So that's one life achievement. That's good. But everything else is sort of, so.
Oh, that's fantastic. Like especially going through the like the public defender's route. I know you're not a public defender now, right? But like that, but I think that's pretty inspiring. Like that's like peak inspiration. Like,
Yeah, they do good work. And I think that working with the public defender, it gives you kind of a interesting outlook on what the law means, because the number one thing people ask is, how could you defend that person? How could you work for that person? But that's not what our justice system is about, right? The justice system is not about who I choose to work for. It's about, does this person have representation?
mm,
Because the law is not easy to learn. It's just not, and it's so they have to have somebody do it, and I think it's a good thing.
yeah. I think that it's hard for even myself, who like understands that logically, but emotionally can be a bit difficult.
For
Okay,
sure.
all right, so on those lines though, like you can represent a person, but do you think that there are ethical ways to do that? Like, beyond of course being doing something illegal, but like classic case would be in a rape trial, like you can defend a person accused of that, and there's different ways to accomplish that. Like, how dogged do you think someone should be?
The lawyer should be as dogged as possible, right? Our legal system is about, you have two zealots on both sides pushing everything for their side. And the person who should be the gatekeeper on what arguments can be let in should be the judge, right? And so, it's true. There are cases, especially with rape cases, there are arguments now that are not allowed, that judges will not allow into trial, that were allowed in trial, going back 50 years. One would be like promiscuity of the victim. That was something that was very common. Now there's very strict limits on what you can do, because those were set, by legislatures and judges. These are, we can't let this in. But I don't think the responsibility should fall on the attorney to not make an argument that may work, if it may work, because we swear an oath to do that, right? We have a obligation to our client to try to do everything we can to make sure that we're not leaving a good argument, legally speaking, off the table, even though it may be kind of fucked up, right? I mean, a lot of the law is fucked up, if we're being honest.
Yeah. I
Like
understand
Roe v.
what you're saying. That that should be, like setting the rules should be the boundary of judges and lawmakers, and then you simply work within those rules. But I mean, we've all heard them. We've all heard those arguments, and they are pretty vile. Okay. Well, we'll leave that there for now. Maybe that'd be something else to discuss sometime. I think it's an interesting line of discussion.
Yeah, I'm sure Pisco would agree with me on that too.
Oh, what? Sorry, I missed it.
Disagree. You're safe.
Okay. Cool. Sorry I'm late, guys. Sorry I'm late.
No problem. Glad to have you here. All right, so let's get started. Hello all. We're having a special debate between these two individuals who I'm really happy to have on Roe v Wade. So we'll be talking about the case itself and whether it makes sense that it was decided the way it was. And we're doing it from a legal perspective rather than a random asshole on Twitch's perspective, which will be new. We don't try that on much of my panel, but so I'm really excited. Okay, I'm going to introduce these two and we'll get started. All right, first we'll start with Lactoid. Thanks for stopping by. Thank you for agreeing to do this. I was really excited when you two started talking about this.
Yeah, no, thank you. I appreciate you bringing me on. This is an interesting discussion. It is going to be very legal, I'm sure. So it's going to be maybe a side that isn't often talked about in, besides the last couple weeks, usually isn't talked about in Twitch politics. Normally is the ethical and kind of what, the philosophical justification of, life and all that stuff. But we got two legal minds here to talk about it. So that's going to be fun.
Thank you. Next, a person close to my heart, my man Pisco is around. Pisco, so happy to have you around. It's always a treat. So when I saw this opportunity, I jumped on it, especially to get you in your element, which I usually it's you versus other people who don't have an idea of the law, so it's a pretty easy battle for you. But, like a bit of a challenge for you. How are you? So are you excited to be here?
Yeah, totally excited to be here. Absolute pleasure, as always, Prime. Thank you for putting it all together. I feel like a lot of my conversations the last week have been centered around Roe v. Wade and Casey and the legitimacy of the court and its view on it. And so I'm super happy to have Lactoid to discuss with, and yeah, just glad to be here.
Okay, all right. So I'm gonna take myself off screen. Would you guys prefer this or this? What do you like?
No, back it up, please.
All right. Gotcha.
Thank you.
All right.
I agree.
Fanatic does it the other way, so I don't know. I've been thinking about it. All right.
Can you give me 1 second to get an iced tea though, Prime?
Sure.
Would that be too much to ask for?
Okay. No, go ahead. Yeah. All right. Then I'll put myself back on screen.
That won't fly in court, Pisco.
Yeah. Right. A few months ago, I served on a jury, and the defense, defense was the lawyers did not make a good impression on the judge, and oh man, the judge. I remember the judge giving looks at the defense lawyer, and I could see her asshole clenching because I think by the end she was terrified of this judge. Like just multiple things just went wrong. It was a shame. Anyway,
They're so scary.
yeah, it really is. It really is. But all right, I'll let you guys do this. So Pisco, you're for the pro side, so I'll let you go
That's right.
first. Yeah.
Yeah, sure. So, about 50 or so years ago, Roe versus Wade was decided in a line of cases, I argue, that have to do with one's individual right on the fundamental decision to bear or beget a child. The court had, in the years prior, found that through the 14th Amendment or through other aspects of our constitutional system, that individuals have implied rights under the Constitution. Among these include the right to be able to get contraception, the right to raise your children the way you want to, teach them the languages you want to, the right to be free in many cases from forced sterilization. And that was not a controversial view of the court. It was in line with the decision of multiple justices over the course of many years. It made sense given the structure of the Constitution. The Ninth Amendment, for example, seems to imply or seems to understand that there is going to be such an exercise as looking for implied rights somewhere in the Constitution. It is in line with our incorporation doctrine, where we are applying the Bill of Rights as to the states. And so at the time, Roe versus Wade, which recognized an individual right to abortion, was in line with what the court was doing at the time, which is trying to understand what implied rights existed under the Constitution, and to see what the limits of those rights were. Now, two things. The court had made a couple missteps in the past in terms of finding implied rights where nowadays we would recognize there are no implied rights. This is the Lochner era of economical substantive due process, where the court was, I would say, improperly finding implied rights in the domain of economic regulation. But that didn't undermine the entire exercise. And there really is, I think, something to the notion that the Constitution recognizes, even if not explicitly there, certain rights. The second thing that I want to focus on is that Roe versus Wade represented a recognition that individuals and their governments are not necessarily that this relationship is not one that can be transcended easily. And so I think that it's important for us to recognize the due process rights of individuals and the interests of states, yes, in acknowledging those rights and sometimes overcoming the individual rights, but yeah, that this right to abortion exists, that it's consistent with precedent at the time, and that the stare decisis factors for overturning Roe v. Wade point solidly in the favor of maintaining it.
Okay, Lactoid, please.
So, all right, mine's a little bit, might be a little bit longer, but I'd like to start off my opening with a quote of some of the legal reasoning from Casey versus Planned Parenthood, which is not Roe, but it's a case that came after. So this is from Casey. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. So despite this rock-solid legal analysis from Casey, I'm a little bit black-pilled on kind of the entire legal framework here. You know, I just want to start out by saying my personal conception of rights is incredibly different than my understanding of how the law exists and how the process of law should exist. I think that the bad with the law in this country goes back to vague laws, right? I do agree the Constitution should be broader, and it should be more specific, and it should protect more rights. Personally, I am firmly, morally in favor of the full legalization of gay marriage, gay sex, bestiality, necrophilia, and the full legalization of all drugs. That said, I'm skeptical of partisans interpreting the Constitution to flex the law into what suits the political zeitgeist of the heyday. It should be done the right way, because I'm against hacks bending the Constitution to fit their dastardly intent, like Korematsu, right, protecting race-based concentration camps, Wickard, which allows the feds to do anything, Chaplinsky, which decided that freedom of speech doesn't exist when you call a cop a fascist and he beats the fuck out of you because, well, them's fighting words. Or, which I think is going to be a relevant case, it's going to be brought up several times here, Scott v. Sanford, which, like Roe, had horrible historical analysis to interpret the Constitution in a way that it was not written and could not reasonably come from the founding in order to determine Black people can't be American citizens. In contrast, originalism is the belief that legislation must be interpreted from the position of those who wrote it, not what we can twist it into now. This is the fundamental idea of originalism. The judicial branch is intrinsically conservative, a status quo branch of government intended to protect from government overanalyzation. Lochner was brought up. In my personal morality, Lochner is fantastic. The horsemen were sick, right? They protected classical liberalism, they protected libertarianism, but I'll be honest, they didn't have the best grasp of the Constitution. So I think we have to go over the cases that, and I'll just admit these because I'm sure these are going to be brought up. These are the cases that I think are weak, right? All the cases I've already mentioned, every case affirming Civil Rights Act over private citizens, Obergefell, Lawrence, Griswold, and yes, Roe v. Wade. Roe is faulty for several reasons. Bad historical analysis, a claim not to be determining when life begins when it sort of explicitly does and definitely implicitly does, and ignorant of the attempt of the drafters of the 14th Amendment. Its trimester framework is broken, and they had to patch it up with Casey, but the underlying problem remains. Alito's decision was coming from a mile away. Roe was weak, Casey was weak, they're inconsistent, they provide no justification for the trimester framework in Roe, or the viability lines in Casey, they just assert it abstractly. This was recognized the day it was ruled. Many Democrat politicians pushed to make abortion protection legislation, because even they knew Roe was fucked. Ultimately, we can argue all day about whether or not this is a good decision, which I think we should because it's fun. But SCOTUS has the authority to do two things. A, overrule SCOTUS, and B, interpret the Constitution. Now, I understand, Pisco, that one of your main arguments here is, stare decisis. But while it can be, I guess, persuasive for the Supreme Court, it's not actually, it doesn't have, they can overrule it, right? I mean, look, Casey overruled major parts of Roe. The two abortion cases are in conflict, and one is the Supreme Court directly overruling itself, right? Casey is overruling the stare decisis of Roe, and yet Casey is one of the abortion cases that is supposedly guaranteeing the legal right to abortion. Roe never even specifies where in the Constitution it's getting its logic from, right? It never specifies what undo means. Under this line of reasoning, Alito's decision could just simply say, fuck you, abortion is legal across the board because 14th Amendment protection of life. And you might think that's ridiculous, but I mean, argue against it, right? Why couldn't the court say, we decided we can protect life of persons under the 14th Amendment? Obviously, the court defines persons to some extent, and the court could define a person as a fetus because there are, going back, there are laws criminalizing killing a fetus as murder to this day if it's not the mother. And the people at the time of the 14th Amendment seem to not like abortion too. So, and they were passing laws, therefore, federally, we can just make it illegal too. So now you can't abort. I think that the experts who didn't see this coming suffer from what I call law student syndrome, which is that what they think, whatever is said by their lib con law professor is unchallengeable. I assert living constitutional theory is arbitrary, obviously politically motivated, and that originalism is the only actual structural legal theory. Instead, we live in under the hellscape that is living constitution theory implemented by FDR and his fascist court of clowns, and means that essentially the Constitution doesn't matter. That said, even though all this is fake and arbitrary under living constitution theory, I think Roe, even by that standard, is extra fake and arbitrary, and I look forward to arguing that position.
Good to go.
All right, please.
I'm curious, Lactoid. So
Hit me.
you do not believe in implied fundamental rights?
No, I think that there are implied unenumerated rights of the Constitution, but I think that when you have a situation where, like, I think you have to go back and again, so you don't get crazy with it, you actually have to look at what was the intent and the acceptability of what was being drafted at the time of drafting of that particular legislation.
So to be clear, you agree with substantive due process as a legal theory?
And I'm asking this because I haven't heard a very firm definition here from anybody, even in law school.
Yeah.
So could you just please describe what you mean by substantive due process?
The notion that the 14th Amendment embraces more than just procedural protections, that the 14th Amendment is a source of implied fundamental rights, that among these are well, I'll just leave it there and then let you answer that.
I'm skeptical of it. I could accept it if it wasn't so glaringly in the face of something that wasn't accepted at the time, right? So I can understand there could be a theory of, well, we're faced with a new situation that we've never faced before, like let's say computer privacy or something, right? Or something that just simply couldn't, because of technological limitations, couldn't come up at the time. I could see, us taking a look at that and say, well, based on the writing here and the interpretation, right, they very well could have meant it to apply to this, right? But at the time of the drafting of the 14th Amendment, it's, historically obvious they did not mean for it to apply to abortion. I think you would have to admit that.
Oh, I'm not going to get to abortion yet. My curiosity is whether or not you think that the 14th Amendment is a source of any fundamental rights for individuals, not just procedure.
I think it could be. I think it could be for things that were not decided at the time. I'm unconvinced.
Things that were not decided at the time.
Yeah, things that were not obvious at the time, right? So when you have the 14th Amendment being drafted in a time which was so obviously against abortion, I think it'd be dishonest to assume that that's something that they even could have meant by drafting it. Now, could you make the argument that they actually meant it for new situations today? I would hear those arguments, and I could agree with some of them. But for abortion, it's not a new thing.
That's odd. So the 14th Amendment could be a source of implied rights for new phenomena not found at the time. It would seem to counteract the kind of originalism or focus on history that seems to be the bedrock of Alito's opinion. And if indeed I'll leave it there. Well, what do you think with that?
I disagree.
What do you mean? You've just told me that the 14th Amendment is a source potentially of fundamental rights, but only for new phenomena not known to the founders or not known to the framers of the 14th Amendment, I suppose.
Yeah, if it follows the exact same kind of if it shares some of the fundamental elements of things that it was applied to at the time. So, I can't think of a great example off the top of my head, but if you have an example of something that's just come in, that's sort of a modification of a prior well-established unenumerated right of the 14th Amendment at the time. That's something that I would consider.
Okay, but at least you agree that the 14th Amendment is a source of unenumerated, non-textually based rights. Is that correct?
I don't have a firm opinion on that. I would be open to the argument.
Wait, isn't one of the big objections to abortion on Roe v. Wade that it's not textually found anywhere in the Constitution?
So my objection here to Roe v. Wade is that, but again, the reason why I have such a strong opinion on this in particular is because that it's combined with the fact that at the time of the drafting of the 14th Amendment, there was widespread opposition to this. And obviously, if any kind of honest historical analysis, you would see that they did not intend it to apply to that.
Yeah. Excuse me.
Their originalist intent did not apply to that, obviously.
That's you taking it one level down the road. That's you assuming that there could be such a thing as a fundamental right in the 14th Amendment, and then having some kind of analysis to distinguish abortion from other stuff potentially. I'm asking you one level removed, and what you're telling me is that you don't have an opinion on whether or not the 14th Amendment is a source of unenumerated rights, that you're agnostic to that fact, but you don't have an opinion on.
I'm somewhat agnostic. I think either way, Roe is trash, right? If I strongly do, obviously Roe is different because at the time, they were not in favor of abortion when they drafted that. And if I don't, well, if I'm not in favor of unlimited rights, then obviously I'd be against Roe v. Wade on that basis too.
Well, this distinguishes you from Justice Alito and his draft opinion, wouldn't it? Because you would agree that Justice Alito's opinion does acknowledge that substantive due process and implied rights are the law of the land.
Sure. Yeah.
Okay.
I mean, I like I said, when it comes specifically to the unenumerated rights implied by the Constitution that don't have to do with, like, that have to do with new scenarios. I guess one of the issues is I can't think of like a very firm example, but
how about this? How about the incorporation doctrine? So that as you must acknowledge, the Bill of Rights, Second Amendment, First Amendment, all these wonderful amendments, as originally thought when they were passed in, I don't know, 1801 or whatever, whenever it was passed, 1791, those did not apply to the states. You agree with that premise?
My understanding is that's true, and then the 14th Amendment in 1868 is what made it apply to the states.
It doesn't say, the 14th Amendment doesn't say that. The 14th Amendment has been understood that there's this implicit concept of liberty where it's a source of substantive rights, and that's how we get to the First Amendment applying to the states. You're not bringing that doctrine into question, the incorporation doctrine, are you?
So, well, I disagree when you're saying that it doesn't specifically state that. I'm reading the 14th Amendment. I think the language is pretty clear, and I think it was understood at the time and intended by the founders to apply to the states. That was part of the reason of drafting it, because they wanted to avoid
the Bill of Rights to the states. You think that that's explicit in the 14th Amendment?
I'm reading it here. I think it's both. It's pretty clear based on the text, and especially clear based on what their intent was in drafting it. Again, the originalist perspective. You go back to what was the purpose of this? Part of the purpose of this was to apply the Bill of Rights to the states.
But what is the language you're pointing to? That the state shall not deprive individuals of liberty without due process of law? That is a source for interpreting the Bill of Rights to apply to the states. That's a rather odd way to say that we're going to apply all the Bill of Rights to the states.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law.
So where would you find
production of law?
Where would you find the incorporation doctrine to be properly sourced from? The privileges or immunities clause of the 14th Amendment, or the due process clause of the 14th Amendment?
I think just a little bit of both. I think the privileges and immunities clause, I think, is probably a big part of that, but I think it's probably a mix of both. And again, I think the element. I'm not a pure textualist here. I think you have to look at what the intent was of what they were getting at with this amendment. I think that was also an essential part of the analysis here.
It seems odd because if the privileges or immunities clause applies to citizens of the United States, and as you know, the due process clause of the 14th Amendment applies to people, and so it would seem weird to say that it's a little column A, a little column B. They're addressing different groups of people. So how can it be that this incorporation doctrine, don't you have to choose? Why do you say it's both the 14th Amendment and, both the privileges or immunities clause and the due process clause?
I don't think it's a contradiction to say that they both apply. My question for you is, do you agree that the 14th Amendment was intended to apply to all the states, to extend the Bill of Rights to all the states? Do you agree that was the intent of it?
I do so unabashedly. Well, I'm not
the intent. But like, put yourself in the originalist shoes for a second. Do you agree that was the original intent?
No. You think
Really?
the original intent of the people who framed the 14th Amendment was all the Bill of Rights are applying to states?
Yeah. I mean, maybe it's a different legal analysis we can take a look at. I think that applying the Bill of Rights.
What's your historical evidence of that?
I mean, I'll have to do a lot of research to actually bring up the treatises and shit on that. But that's my understanding of the 14th. Part of the idea of the 14th Amendment was to apply, is post-Civil War, right? It was to apply the Bill of Rights to every citizen in the United States. So you couldn't have states that were, coming up with their own religion or coming up with their own, specific policies that were an abridgment of the protections granted by the Bill of Rights.
That's right.
That was the intent of it.
You can say that's the intent. What you're telling me is, well, there's some treatise somewhere that provides historical evidence that, I don't know, the people who drafted it thought about it.
I've been at a law school for 2 years now. I didn't specifically research that specific section before.
But you are not that has to be read in. You'd agree it's not explicit. That's something that you need to those are implied rights.
So it's not implied, it's a historical analysis, right? So it's not just about like we read it and then whatever somebody today thinks it means is what it actually means. It's about taking a look at it and then doing a deep dive into what was the purpose of this, right? And when you have a situation in which you have a amendment like the 14th Amendment being crafted at the time in which there is, already before the 14th Amendment and immediately afterwards, a massive shift towards pro-life agenda, I think you have to acknowledge the 14th Amendment had nothing to do with that. Do you at least agree with that? The 14th Amendment at the time of drafting was not intended to apply to the abortion debate.
I agree that it not to the specific policy of abortion, but of course we don't read those rights that way on the policy level. It's not meant to apply to a specific set of circumstances that existed in the 19th century.
So let me ask you this then, Pisco.
Yeah,
so
sure.
You're saying that it doesn't apply. So at the time you agreed already that the 14th Amendment did not apply to abortion at the time of drafting. So my question for you,
you asked me, was it intended to?
Sure.
They did not intend it to. No.
Right. The people who drafted it, even though they were well aware of abortion existing at the time because all these states were legalizing it, did not intend for it to apply to abortion.
That's correct. They also didn't intend, just to be clear, they didn't intend to desegregate schools in the 14th Amendment.
Sure. So before we jump to Brown, I want to hold you specifically to this, specifically with abortion. Why is it that they don't intend for it to apply here, and so that doesn't apply there, and then 100 years passes or something, and then now all of a sudden it applies? Can you explain that constitutional analysis? Like, what is the constitutional significance of 100 years?
So we do not look to the origins of a fundamental right that's implied, in my opinion, just based on the particular circumstances that existed at the time of the ratification.
Where do we look?
If that were the case, you would have to, which I guess you do now, and you've conceded at the start of your debate, you'd have to deny Griswold, you'd have to deny Lawrence, you'd have to deny all that entire line of cases. I'm assuming you'd have to deny the child rearing cases, wouldn't you? Where is this huge history for all of these rights? And I think that your style of interpretation, which views these things hyper narrowly, it's abortion qua abortion, as opposed to the decision whether to bear or beget a child. That's what's leading us there. This myopic focus on the individual set of circumstances. Just because they didn't at the time think about abortion when they were crafting the 14th Amendment.
They thought of it.
You think that they thought about it in the draft in the 14th Amendment?
Obviously, it was literally at the time of the drafting, right? Like just before the drafting and up to 1905 is when we saw like the massive pushes for the pro-life agenda in the United States. And the 14th Amendment, like despite the fact it was already there, the Supreme Court did not enforce this on the states. It was not intended to be enforced on the abortion question specifically. And my question I asked, and you agree that
the drafting of the 14th Amendment isn't like this history where they considered abortion and then they rejected it at the draft of the 14th Amendment, correct? There's no it wasn't part of the decision. Okay,
so there has to be, I agree with you, whenever we're doing any kind of historical analysis for any reason, there has to be some level of, good faith in analyzing whether or not, what is the reasonable application here. When you have a court draft the 14th Amendment in this political environment.
When the court draft?
Sure. When you have Congress and then you have the Congress draft, and then you have the legislature, right? And then you have the court who now interprets that and applies that, right? Arguably, I would say they do apply it, and that's a civics lesson. But when they apply it and they interpret it, and up to 1905, like the laws just kept getting more and more strict and expanding across the states. And the 14th Amendment was not a block to this. It was not a contention.
You're hammering on the same point and you're repeating yourself.
Because you did. Wait, hold on. Because you didn't answer the question I asked before, right? The question I asked before was, you agreed with me this was not intended to apply to abortion, and now 100 years later, right? The Supreme Court intended for it to apply to abortion. What is the constitutional significance of 100 years? Could you explain that to me?
The constitutional significance of 100 years?
Yes.
I'm not sure that there's a constitutional significance in a given lapse of time, other than our developing notions of, for instance, for rights that we think that are attached to this, evolving standards. Think like the 8th Amendment. That there might be some relevance in time lapse there, and certainly between I think a good example is Plessy and Brown, you can see the fact that some decision doesn't seem to be accepted by the people, and or the factual assumptions on which a decision is based don't seem to be borne out, or time has seen developments in the law. That time can be significant for that reason, but it's not the time, it's what the time has what insights it has given us. So another good example of that would be Lochner. The 20, 30 years, or I don't know, the 30-ish years between Lochner and, now I'm not, is it West Parish Hotel? Whatever the case was that overruled Lochner, that was significant, not necessarily for like the 30 years, but what we learned in those 30 years in the Great Depression. And certainly, if you're gonna, sting me with, well, what did they intend at the time of the signing, and you're gonna marry people to that, you got the answer for Brown.
I've already said, I haven't fully read through Brown, but I started off by saying I'm not a huge fan of the actual legal analysis there. I think
Brown v. Board was wrongly decided.
Like I said, I haven't fully read through it. I'll have to read through it to see how much of a complete arbitrariness they're basing off of Roe is. But I remember from what I recall. I mean, this is a Roe discussion. I mean, from what I recall from law school, I remember reading through it, and I'm thinking, wow, that some of the legal analysis here seems a little bit weak. On the Roe case in particular, I wanted to comment on the answer that I finally got, which was that the 100 years doesn't actually have much of a constitutional significance. I assert that the Constitution has a procedure for amendment, right? When you want to add certain things to the Constitution, there's a way to do that. And that is spelled out, specifically how to do it. And so when you have 100 years, even if it's 100 years, that doesn't mean the Constitution just changes based on things we have learned, right? If it changes based on things we have learned, it's up to Congress, the people who have learned have elected to change it, right? That's how the process works.
You're assuming that the only way to interpret the Constitution is by looking at the particular practices that existed at the time.
It's the only good way.
Well, it's not the only way, and it's not been the history of this. It's not the only good way. It's not been the history of this court. And to accept that at the time means that you have to accept Plessy. And you can get away with it and be like, oh, I haven't read Brown. But you know what Brown's about, and you know what Plessy's about, and you know what the Equal Protection Clause is about. And in the 1860s that when they passed the Equal Protection Clause in the 14th Amendment, they did not think they were segregating schools. You would agree with that fact, wouldn't you?
Probably. 14th Amendment probably shouldn't apply to the segregation of schools.
So you think Brown v. Board was wrongly decided?
If that's the central holding, if there's no other rationale besides that, then probably, yeah.
What other rationale would? Okay.
I don't know. I've been telling you multiple times, I've read a couple cases.
This kind of analysis will get you. This kind of analysis would focus on the particular practices at the time of enactments will, instead of focusing on the values that are essential.
Your values.
The values at the time. The values at the time. You are absolutely, there is a lodestar. There are fixed things, but it's not fixed at the level of generality of the particular circumstances of the time. It's the particular value.
All right,
and it makes total sense.
I'm going to do a little bit of because I know what you're doing, right? You're saying, okay, logically speaking here, there's not a direct pathway. So you're just crazy if you disagree with Board, right? Now or Brown. So I understand that tactic. I have to ask. Yeah, that's what I'm thinking is happening here. I have to ask, with Dred Scott, for example, Scott versus Sanford. I have to, would you agree with me that, it's a universally condemned case. It's especially condemned by originalists because there's no actual basis for a lot of the historical arguments from Sanford. But it was a understanding of the time from the Supreme Court who was writing based on the experiences of people living at the time. Do you have any argument against Sanford from a legal procedural point of view, or do you just think the outcome is racist, so it's bad?
No, it was wrongly decided the day it was decided for many reasons. What in that case, for instance, the court took crazy steps in striking down the compromise, the Missouri Compromise, and taking what I would say is totally unprecedented steps in overstating its jurisdiction over things that were not even up for discussion and weren't even before them. There were problems and also in terms of just reading the Constitution the way that Chief Justice Taney, I think that's his name, was reading it, nowhere in the Constitution does it say that citizens of a state need to be citizens of the United States. That I don't know what the basis in constitutional philosophy is. That's the kind of jurisdictional holding. Which, by the way, people point to Dred Scott. People point to Dred Scott and be like, "Isn't that an example of how you would want to overturn a case in the context of stare decisis?" Dred Scott was overturned by civil war. Dred Scott was overturned by the 13th Amendment. And guess what? Dred Scott 13th. Or 13th and 14th, I guess. Yeah.
Yeah. Well, no, it was mostly 14th because they already abolished slavery before then.
There's multiple holdings. There's multiple holdings of Dred Scott. And in that particular case, the key holding, the jurisdictional holding, is still good law. In order to be, for diversity purposes for federal jurisdiction, in order to be a citizen of a state, you need to be a citizen of the United States. And so in that sense, Dred Scott wasn't overturned by court decision. And what's more, we're not even talking about stare decisis. You can give colorable arguments for why Dred Scott was wrongly decided without accepting this originalist frame of mind. And so I don't know what it has to do with the problem of viewing the 14th Amendment solely in the lens of the particular circumstances that existed at the time that that particular principle was enacted by Congress or the people.
Right. So the reason I think Dred Scott was a fucked up case is because of the originalist kind of lens here. I think that when you have a court decide that wrongly decide that, well, look at the behavior of the United States, look at the policies of the United States, look at how the values of the citizens and how we have treated black people. I mean, obviously there was no intent for them to be people. That was the central logic underpinning the idea, right? Despite the
more
fact
than that, I mean, you're doing a disservice to.
That was the central argument about why black people couldn't be citizens, right? That was the aim of it.
They weren't ever intended to be part of, that they were separate races,
right?
It wasn't
right. But the reason why that historical analysis is bad is because, well, first reason, it's not found in anything, and then B, there were freed black men who were citizens and who owned slaves before the Civil War. So they just ignored that. They ignored that historical analysis, and they just said this has never happened.
That you're ignoring that right after the founding of the Constitution, there also existed. There was no prohibition on pre-quickening abortions in almost every state.
We can talk about that.
Law. So you can do this historical. You can do this historical analysis as much as you want. You're always going to find cases, and also people like me aren't against looking to history. And history is extremely important. What the practices at the time are very informative to what matters. Guess what? Because a lot of these constitutional provisions do not explain themselves. What does it mean to abridge the freedom of speech? Right? Who the hell knows?
What does undue burden mean? Right? I haven't heard that yet. Right? What does that mean?
Well, it means to put a substantial obstacle as a purpose or effect of putting a substantial obstacle in between a woman and an abortion. I mean,
what counts as substantial?
We can keep playing this game. Like that's what the court is in the business of doing, is deciding what is substantial, what's not substantial. Just like the court will oftentimes be in the game of deciding what's reasonable and not reasonable. Yeah. Let's not get far afield. We're still at a very high level of generality of constitutional analysis, which is, so far you've told me you don't think the Equal Protection Clause prevents segregation. Because at the particular time and moment the 14th Amendment was passed, they didn't think that they were getting rid of segregation.
They didn't intend for it to apply. Now, am I personally morally against it? But then I think that part of that is us as the people not doing our fucking job and passing legislation to actually get this shit codified, instead just relying on weak cases, right? I mean, for years now, Democratic politicians have been arguing to codify Roe v. Wade. They're saying this needs to be national legislation because Roe is a weak case. And every time they came into power, every time they had the political capital to do so, they didn't do shit, right? So
you don't even think it's constitutional. You mentioned Wicker at the start of your conversation. Do you think it would be constitutional for Congress to pass a law that puts into being a universal right to abortion in this country? You would think it's unconstitutional, wouldn't you? So don't play this game like you.
I don't know.
Like you were deriding Wickard and the Commerce Clause at your opening. You would be.
Do you agree with Wickard?
You would be in the litigation. It doesn't matter whether I agree with Wickard or not.
That matters. I want to know. Do you agree with Wickard?
Yeah, I do agree with Wickard.
Oh my God.
I do agree with Wickard. But that's neither here nor there. The point is, you don't pretend that you care about democracy, because the moment that this would come into the Supreme Court, that Congress
democracy.
The moment that Congress passed a universal right to abortion, people like you would be on the steps of the Supreme Court arguing that it was an unconstitutional usage, an ultra virus act by Congress, and that they have no authority to do so.
Okay, hold on. So I'll have to actually consider it, because I wouldn't say it would be anti-democratic if Congress passes legislation to do something. That would be very democratic, right?
No, so I think that you would be against it. I think that you would be.
Hold on. But let's keep in mind, you're calling me undemocratic while you are advocating for a unelected body of judges to determine that states cannot make a law about this. That's what you're advocating for. And in the same breath, saying that I'm against democracy.
I understand that the whole point of individual rights is to take away, is to constrain the people.
Constrain democracy.
Democracy.
For sure.
And so appealing to democracy, I think for you is wrong for two reasons. One, I
didn't start by appealing to democracy. You started by saying I hate democracy.
Didn't you say? Then I must have missed the course of the conversation. I'm not going to be able to recall right now what brought me to mention the fact that you were like, for years Democrats have wanted to pass legislation to codify Roe v. Wade, as though that would be the proper way to do things. That was your implication, right?
So that would, I think, clearly that'd be better than Roe, right? Whether or not, I mean,
so the implication you were making very obviously was that the right way to do this is to submit it to the people. Am I wrong?
Sure. Yeah. Well, but yeah. The right way to do it would be through legislation, and especially not rely on a case that's as weak as Roe. And we can go into why I think Roe is weak, like the 3-trimester framework. Because
we will get to the substance of Roe, but just to be clear, one reason why you shouldn't appeal to democracy in that sense is because the first question is deciding whether or not it's a fundamental right. The whole point of fundamental rights is to be free from democratic impulse. And so in that sense, it's question begging. We first have to determine whether it's right, regardless of put it to the states. And the second reason I think it's hypocrisy is because I think you would be against federal legislation, not just for policy reasons. I think you would think it's unconstitutional for Congress.
So instead of you speculating on what I may think on something that I'm undecided on yet, instead of you speculating on what I will or won't say about something that I'm undecided on yet, I would like to talk about Roe.
Well, no, I want to square away. I want to square away what your thoughts are on fundamental rights, implied fundamental rights, before we get into Roe v. Wade. And so I'm going to start asking you the questions that everyone's going to ask you, which is vaccine mandate. State passed vaccine mandate constitutional? No rights allowed there.
Likely, yeah. I mean, so they and the only reason is because my understanding is there was a case before where they did it, and the Supreme Court decided, and this was very close.
There's a case before where it did it in Roe v. Wade.
Hold on, this was very close to the founding of the country, and in fact, I think if I'm not mistaken, it was
Jacobson. Jacobson's in the 1900s.
No, there was something about There was one about smallpox too.
Well, George Washington had a policy of inoculation, but no one denies. I'm not talking about the military. I'm saying a vaccine mandate, and the punishment for not getting a vaccine mandate, lactoid, is death. Constitutional?
I think that'd be cruel and unusual. So no, not constitutional. 8th Amendment.
Okay, so
or 5th. I don't know.
You go to jail for a year?
I would still think that'd be cruel and unusual. I mean, you could probably attach some kind of fine to it. Excessive fines have been repeatedly, determined by the courts to be excessive and cruel and unusual. I'm not denying cruel and unusual because that's spelled out in one of the bills. Like that's literally spelled out.
Well, it's whatever it means to you, right? And I'm assuming that you agree with
it's better than a penumbra.
I'm assuming you agree with Justice Scalia that that the death penalty as applied to 13-year-olds is constitutional. That's not cruel and unusual.
I mean, was it probably?
Yeah, I mean that's what Scalia thought. That's where her historical analysis brought him, that it wasn't cruel and unusual to put 13-year-olds and 14-year-olds to death. And so I don't know why you get to now in the very liberal society determine that 1 year in jail is cruel and unusual.
Well, hold on.
A vaccine mandate?
For a vaccine mandate, I'm assuming that Scalia is not saying that the 13-year-old should be killed for refusing a vaccine. I'm guessing what the death penalty is applying there is for murder. Am I wrong with that?
Well,
hold on. Hey, whoa. Stop.
Felony.
No, murder. Name.
Well, no, Justice Scalia is against the other cases too, where he says that the death penalty can only be for murder. He was in dissent in those cases as well. Take something. I mean, I don't even. It's crazy to me.
Okay, a ridiculously serious felony.
Do you think it's unconstitutional to put someone to death for embezzlement? or to put someone to death for
Yeah.
fraud?
I think so.
Why?
I think that's pretty clear based on like all the rulings and interpretations of the clearly spelled out cruel and unusual that
It's not
exists.
clear to Scalia. Scalia disagrees with you. I mean, there you have two originalists disagreeing on.
Sure.
Okay.
Well, hold on. So I'm not saying I'm like disagreeing with Scalia in all of his interpretations. I already said that yeah, likely there's not a constitutional bar on certain punishments for people who commit horrific crimes. Right now, I do think it was a little bit weaselly to try to like mix the 1 year with the vaccine. That's ridiculous. But death penalty for 13. We're not talking about refusing a vaccine. We're talking about a heinous felony in that situation, like murder or like maybe raping 8 kids or something.
Well,
I don't know. That's like an interesting like legal question about whether or not like that's cruel and unusual. I think when like the punishment fits the crime in that scenario, it's probably not cruel and unusual.
Okay, but the vaccine mandate is not unconstitutional if it's like a tax. You said, right?
I said maybe some kind of fine, and right. maybe you could attach some kind of punishment to it. I don't know.
Here's the
further
kicker.
Punishment to it.
Here's the quick, and then we can get on to the actual lines of cases, which is
or Roe, where now we're in.
Suppose the government says to a woman who's pregnant, or says that we reserve the right to force any woman we deem to have an abortion. We get to decide for you whether or not you're going to have an abortion. Is that constitutional?
I do not think that'd be constitutional. I think at the time because at the drafting of the 14th Amendment, they were doing the exact opposite. So obviously their intent wasn't to have that happen.
Wait, so because there was a policy determination and there was laws enacted that were contrary at the time, that now we have to follow all the laws that existed at the time?
I think it obviously contradicts like the intention of the 14th Amendment at the drafting.
Why?
I think it obviously contradicts the enactment of it, right? I mean,
why would a law that forces certain women to get abortions, why would that be unconstitutional?
I've already explained it.
Because at the time there were laws against abortion. All right, we changed the laws.
Combined with the 14th Amendment, yeah. Now you could obviously change the 14th Amendment. You could change the Constitution to say the government's now allowed to force people to get abortions. And then hold on. And then legally, right? If you did change the Constitution to say the government can force women to get abortions, then yeah, legally you could force women to get abortions.
The Constitution does not say that you get to be free from the government telling you when to get an abortion. It doesn't say that. Where does it imply it? You're the one who's saying that they didn't.
Hold on. At the very beginning of this, I didn't like to completely discount the idea of like unenumerated rights. You seem to assume that I do.
Okay, that's what I wanted to get a clear answer from you on.
I have been very clear. My whole in fact, I'm not even sketchy. We probably spent 15 minutes when me saying like, yeah, there's like a new scenario where like there's like an interesting like modification of rules. Like, yeah, maybe we could apply it there. But in a situation in which during the drafting of the 14th Amendment, you had like a massive pro-life push across the country that the 14th Amendment was not applied to. That is a incredibly different historical scenario, and to interpret it as anything else, I would argue is dishonest.
So you have an individual right to be free from government intrusion in your decision not to have an abortion, but you're not have an individual right from the government to intrude on your decision to have an abortion.
Potentially.
And that's backed up in historical analysis. Somehow think that the Constitution says that you have an individual right to protect the government against having or forcing you to having an abortion, but not into not having an abortion.
Do you think these two, just because they both contain the word abortion, are the same thing, like morally or philosophically?
How can you, on the one hand, be wringing your hands and pearl clutching about the fact that this is so untethered this is judicial lawmaking, it's not anywhere in the Constitution, but you're essentially finding an individual fundamental right to be free from government intrusion in your decision to not have an abortion, your decision to have an abortion, and then to pretend that this is like reasoned constitutional interpretation.
Wouldn't the Fourth Amendment apply to that though? Right, seizure of the fetus.
I believe so. Yeah, no, but I'm consistent.
Right. Okay. So, no, hold on. For Fourth Amendment, seizure of the fetus. Explain how does the Fourth Amendment? Hold on. How does the Fourth Amendment apply to a pro-life policy? Explain that one.
So you think? Well, as
hold on. No. Hold on.
No. Applies to baby.
as applies to women, right? So we're talking about the Fourth Amendment here, okay? So you're saying what is the constitutional basis that would prevent the government from forcing someone to get an abortion? I'm saying, like, potentially here, search and seizure, right? You don't have the right to seize and search somebody, right? Now, does that mean that you can't illegalize a medical procedure?
I'll
Of course.
use that to abortion. I'll use that for
Sure.
abortion, search and seizure. It's a seizure to force a woman to have an abortion, to not have an abortion.
How's it a seizure?
How is yours a seizure?
Because you're literally like, you are seizing the fetus from the woman, and on the other hand, you're just like telling a doctor you cannot do this procedure. How's that a seizure?
So I really don't understand. First of all,
wait, no. How explain to me how telling a doctor it is illegal for you to like do this procedure. How is that a seizure? Explain that.
You're in the same sense of you, I don't know, forcing a woman to do anything or forcing anybody to do anything. Could be considered a seizure.
Oh, okay. Hold on. So we can't. Hold on. So you're saying we can't ban medical procedures anymore? Is that what you're saying?
You can. You absolutely can.
Sure, you can.
You're having this theory that somehow you can. The Fourth Amendment is meant to apply to police actions, by and large. Is meant to imply to
the power of the state, and
it's not meant to be put. And it also, the Fourth Amendment says unreasonable searches and seizures. You know, assume that you have a warrant. Assume that that a judge signs off on all this stuff. Who you're not going to be able to use the Fourth Amendment to save you from all the bad hypos that you have to bite. And pretending at in the 12th hour in the fourth round, or I don't know, the fourth quarter, that I'm going to cling to something. I'm going to cling to the Fourth Amendment. I think it's preposterous.
You just brought up this hypothetical. I didn't hear it beforehand. Like, I'm thinking it over.
This hypo's in Casey.
I'm sure I didn't review that specific part. I didn't review that specific part of Casey then before this discussion.
It's the majority opinion.
It's a majority opinion. Like that's like deliberating whether or not the state can force a woman to have an abortion.
Yeah.
Okay, I'll go back and reread it.
I believe it's in section 3 of the opinion.
You're good. That con law class, fresh in your memory.
Con law was like 3 years ago. What are you talking about?
Wait, you didn't take con law too?
1L.
You took them both 1L.
There's only one con law in my school.
Oh, shit.
Yeah. The point of these examples are meant to illustrate is, of course, everyone understands there is implied rights. I would agree that bodily autonomy and privacy give you private rights with respect to keeping the government out of your decision whether or not to have an abortion, or forcing you to have an abortion. And likewise, I think there's a privacy interest at stake in vaccine cases. Not necessarily that you're going to win on the vaccine cases. I don't think you're going to win on the vaccine cases. But
why not?
Because I think no right is absolute, and you would grant that as well. I'm assuming you do not deny like the tiers of scrutiny analysis, or the fact that you can you can have ways to bypass individual rights. And so I think that everyone wants to accept that there are individual implied rights. Even you do, because you're acknowledging, whether you find in the privileges or immunities clause, or in the due process clause of the 14th Amendment, or both of them somehow, you are acknowledging that there's implied fundamental rights through the incorporation doctrine and this like new circumstances, whatever you're talking about now, which has no basis in history, ironically enough,
because it hasn't happened.
Well, but that's more of a reason to think that there's not an implied right by your own analysis.
It's never happened, and it wasn't happening at the time the 14th Amendment was written, or in any history.
If you're an originalist and if you're tied to the history, why would it make sense to say that implied rights are the ones that aren't deeply rooted in history? They're the ones that were, the 14th Amendment is meant to provide implied rights as respects phenomenon that we never dealt with. That seems to be exactly what Scalia and other originalists are fearing that judicial actors are going to do, is to imply rights for new situations. And so I have no idea why you would ever grant that would be an okay exercise for a judge to determine for themselves what.
Scalia has done it plenty of times, right? Scalia even said, right, Fourth Amendment protects you from police scanners scanning the heat signatures of your house, right? That was a major case. That was Scalia. Again, like changes in technology and changes in circumstances, as long as we're looking at the basis of the right, it can apply. But when you have a 14th Amendment which is being drafted at the exact time, and which is a massive pro-life shift, and it doesn't affect it whatsoever, right? It makes no sense. And any kind of historical analysis will obviously show it can't make any sense. Now, you've been asking me a lot of questions, which is
Yeah,
good.
go ahead.
I want to ask you a question. Okay.
Sure.
Why do I have a privacy interest in abortion, but I don't have a privacy interest in any kind of surgical procedure between me and my doctor?
I don't think that it's best thought of as a privacy right. I think it's one aspect of it, and it's one that the Roe court focused on. But the lines of cases that it was deciding upon, Griswold and others, cases that you reject. And keep in mind here, just a parenthetical note for everyone who's watching.
Contraception, Griswold's contraception.
Everyone who thinks that these people aren't these people, I put you in that bucket.
These people. Wow, that's racist.
The people who are shilling Alito's opinion, and Lactoid's even more extreme than Alito. Lactoid is saying that Alito's wrong about Griswold. Alito's wrong about all that stuff.
Griswold's trash. I thought that for a long time.
Okay, so in other words, it would be constitutional for the government to say you're not allowed to buy condoms. It's a crime to buy condoms. Yeah. That would be constitutional. So says Lactoid.
Yeah, absolutely. What's the difference between progesterone and fentanyl? Explain that one, right? Why is it constitutionally protected for me to like have a pill of progesterone? Well, I'll tell you. If I buy a pill of like fentanyl, or if I buy like a joint, but the whole drug war is predicated on the fact that like Griswold shouldn't exist, but yet it does.
No, because you're thinking as
the logic
incorrectly.
Hold on. I'm thinking as the logic explained in the cases.
Because you're thinking of the right as a certain set of circumstances as opposed to a value. Just like you mentioned the Kylo case, I believe, the thermal imaging case where Scalia very beautifully applies the value of the Fourth Amendment to the constitutionally enumerated areas to today. He is.
No, he's applying a consistency among different methods, right? When we're talking about Griswold, a consistency, right? Consistency is kind of important, right? When we're talking about Griswold, right, we're talking about the right to privacy because we don't want the cops coming in and like searching your fucking house for birth control. That was the appeal made in that case. Now, fast forward, we have the DEA busting down doors to search your bedroom for like marijuana or fentanyl or cocaine. And if that is constitutional, if any kind of anti-drug law is constitutional, how the fuck was Griswold?
I don't think that Griswold is properly understood as you get to do whatever you want in your house. That's not what Griswold.
I agree with you. That's not what it says, but it's talking about a type of a specific substance, a drug, right? Progesterone or estradiol, or the different kinds of things that go into birth control, right? So that as a drug is like that's privacy, okay? Whether or not you're taking progesterone, you got a privacy interest in that, but you don't have a privacy interest in other substances. I don't think it's marijuana.
So the fundamental aspect of liberty that these cases represent, in my opinion, is not thought of as you can do whatever you want in your house, or you can take whatever pills you want in your house kind of case, or you can have sex with whatever you want in your house. I don't think that bestiality is an individual right. I don't think that child molestation is an individual right, or any of that stuff. The key holding.
Hold on, I don't either. Right? Let's.
Okay. But there are people. If you buy the reasoning that you can, Griswold is about doing things sexually or related to pills in your own home or in the private marital bedroom. First of all,
you're thinking about a Bergefell. Sorry, that's the one you're thinking of here.
No, well, we've already read. Do you disagree with Loving versus Virginia? Are you going to say that that was wrongly decided too?
It likely is not constitutional. Now, I want it to be legislated, yeah, but I don't think it's constitutional.
So it is constitutional to ban interracial marriage
under the current flawed constitution. I'm advocating for changing it, right? Okay. You're advocating for keeping it the same.
All right. So to answer your question, because we've gone afield, which is how do you distinguish, and why do I think Roe v Wade is a privacy right for Roe v Wade, but there's not a privacy right with something else, with doing drugs or all that stuff.
Or no, possessing. Griswold specifically, you can possess a pill. It's a privacy right to possess a pill of progesterone,
and later on it's to distribute. Later on, because what Griswold in these cases is about the intimate decision about whether to bear or beget a child. That is what these cases. That's what it says in Eisenstadt. That's the follow-on case.
Griswold never talks about any kind of right with specifically bearing children. Roe v. Wade doesn't talk about it whatsoever. If this was the central thrust, why wouldn't they just say it?
Eisenstadt happens a few years after Griswold, and that quote is in there. I'm not sure if Roe specifically cites Eisenstadt. I actually think they do. I think they cite Eisenstadt. And so it's in line with those cases. Casey explicitly, constantly is referencing Eisenstadt, and that's how they're best understood. And it's totally in line with the substantive due process rights related to raising your children the way you want to being free from sterilization. I assume you think the sterilization cases came out wrongly, or at least, I don't know, you think Buck v. Bell was decided correctly?
There's a couple of them that are in contrast with one another, right? So you got
Well,
Buck
you
v.
think
Bell
you think it would be constitutional for the government to forcibly sterilize anyone they want?
Anyone they want? That's not what Buck v. Bell held.
Well, no, but I'm not asking you I'm not asking you Buck v. Bell. I'm asking you a separate question.
Yeah, I'll have to read the case again. I mean, I do think that some people should be sterilized.
Why would you have to read the case?
Again, I'll have to read the case again to see what they're appealing to, right? Because I want to know if they're like what kind of historical analysis there is. I'm not a walking encyclopedia on all of these cases, right? Now, I do think there is examples of where we should like castrate some people, right? So like repeat pedophiles, I think there is an argument to like castrate those people, and that would be sterilization under. Is that constitutional? I would say so.
Okay, so to make sure that that you feel that I've answered your question is I don't see the right as abortion qua abortion. I think the right is properly understood as decisional autonomy right related to your decision to bear or beget a child and to make that intimate decision, not necessarily one related to the specific historical record on any given practice. Because if I accepted that, I'd have to deny Brown v. Board. And I don't think that that's the best way to do constitutional analysis.
Well, I know, because it's a good talking point. So if we're looking at the what your position here is, I'm curious, right? So what you're saying is that there is a penumbra of privacy that comes to the 14th Amendment, right? Hold on, it doesn't specifically say privacy, but that's where privacy is the penumbra. And then there's like abortion, which is also not specifically said, that's within that. And then like that right is protected by like yet another thing which is not mentioned, which is like the right to beget a child. And then all of this is there's no issue with that.
You're doing the same stuff.
No, hold on. So
you're
hold
implying
on. Why do you got to be as crazy as me then? Explain to me why, or do you have any kind of historical basis to justify?
Yeah.
Hold on.
Do
you have any kind of historical basis at the time of the drafting of the 14th Amendment to justify that there was any intent whatsoever or any reasonable extrapolation from anything that anybody was saying that they intended for there to be a right to like begat a child in the 14th Amendment? Really?
So, yeah. Well, I mean, you are recognizing one by answering that you think it's unconstitutional. I will answer affirmatively, but just to be clear for the audience's sake, Lactoid is also accepting that the Constitution provides a right to bear or beget a child as applied to having the child with respect to the government not forcing you to get an abortion.
Yeah, that's so the 14th Amendment, right? Or the 4th Amendment. That's what I think I appealed to. Okay. Again, off the cuff.
All right. So what I think the 9th Amendment embraces tacitly that there is going to be an exercise of finding unenumerated rights. At the very least, that's what it means. If it's not the source of the rights it's themselves, it's a rule of construction that makes it understood that the rights specifically enumerated in the Bill of Rights and the Constitution are not the only rights that exist. Why put the 9th Amendment in there if it doesn't embrace at least the exercise of trying to find out what those implied rights are? That is a historical
try to find out what they are. Like, what do you mean try to find out what they are? Where do you find them?
To discover what individual rights are so deeply rooted in history and tradition, so implicit in our concept of ordered liberty. That's a quote from Cardozo. That's what the exercise is, and it is rooted by history, but it is not. It's not rooted in the specific practice of abortion, but in the value of what does our liberty even mean? What does it mean to be an individual if it doesn't include the right to determine whether or not to have a family?
I have a hypo for you. What if at the drafting of the 14th Amendment, they specifically said during the drafting, they were like, we do not intend for this to apply to abortion because abortion is murder, right? That's let's say they didn't put it in the 14th Amendment, but that's what they said during the actual proceedings.
You believe in legislative history now? I'll take Scalia's line that they didn't enact that. They didn't enact the committee report. If I'm being non-facetious, I would say I would take that into consideration when interpreting. It wouldn't be dispositive, as it never is. Legislative history is not dispositive. You would agree with that? right?
So, it can be when we got we have an we have an
That's
unenumeration.
convenient. It's convenient that legislative history
Yeah.
unless you want it helps me.
It's convenient that there's we're applying things and we're looking at things on a case by case basis and not just I when we're talking about an unenumerated right, and you have so we're already saying that this is coming out of, it's not even specifically said, right? We're already saying this is coming out of something based on our understanding.
Mm-hmm.
And then we're going to say the drafters specifically intended for this not to be the case. When we're talking about an unenumerated right, I would say legislative history should be dispositive in that case, because how could you possibly fucking argue that they didn't, that they intended for that to happen ever? They obviously didn't, right? Would you agree that they obviously, if they literally were taught, everybody was in agreement, non-abortion, you would say they didn't intend for it to apply to abortion. Not only did they not intend for it to apply to abortion, but hold on. I know you did, right? But now it's they specifically intended for it not to apply to abortion. Yeah. And so how, let's say that happened. Would you still hold your position on, the right to begat a child being found in the 14th Amendment?
I think it would be a lot harder of a case if there's specific evidence that they considered it.
A lot harder of a case. You criticized me for doing that. No.
What?
Yeah, you're saying it's a lot harder of a case,
I don't know what legislative history you're pointing to, but the thing that's dispositive. I'm saying
it's hypothetical. I said if it exists.
Yeah. So
would you?
Is it every single person who voted on it says it? Is it the sponsors of the amendment? Is it the
majority
statement made in a speech?
Yeah,
okay,
the majority of them all signed
in a signing statement say, and this is not intended to apply to abortion.
No, they were and we all agree it's not intended to apply for abortion. Everybody put up their hand, right? And that. I think
that's pretty strong evidence that if it's the majority of people who ultimately end up ratifying, or the majority of states, that's pretty strong evidence. But it's not necessarily dispositive if there's other evidence that exists to the contrary.
Okay,
but I would say in that specific circumstance, I think probably my disposition would be that it's not meant to be.
Okay, then explain to me then how the 14th Amendment, which is talking about something ratified by the states, those very states ratifying it are criminalizing abortion within their borders. How can you look at that as anything but they don't intend for this to apply to abortion?
That is different than a specific statement. Or wait, do you have a problem with that? Are they not the same?
They're criminalizing the procedure at the same time they're voting on this amendment. Obviously,
so is segregation. You're talking about a specific, someone who's essentially a group of people who are saying we will not ratify this without the understanding this is not applying to abortion. But what they did was they signed something that had very general language.
Right. We're signing something that has very general. We're talking about the vast majority of states here.
Listen, I agree. By the early 19th century, all of them had criminal abortion laws.
Except for 2 or 4, something ridiculous.
I'm pretty sure every state in the union by the 1900s had criminal abortion laws. No one's denying that. What you're giving me is an example where there's in consideration of the specific amendment,
right,
the primary actors, whether that's the state, the ratifiers, the people who proposed it, specifically thought about and put to the side this specific thing that you're talking about, or the abortion right. That is not the same as at the same time of passing an amendment, the practice of the states were to do a certain thing. If that were the case, I'd have to accept that Brown v. Board were wrongly decided. But I don't think Brown v. Board was wrongly decided, because I think that these words, these very general, capacious terms, equal protection of the law, due process of law, liberty, you can't be mad that you pass a very general term. Another one is cruel and unusual, and then be surprised with how the courts are going to adjudicate it. They have to adjudicate it, and they have to come to determination about what those terms mean.
So I would say this. I would say, and this is, I guess, to outline my point for the benefit of the audience as well. I think that Pisco said that if we had it in writing that they all agree this wouldn't apply to abortion, then it would be obviously
wrong evidence.
Yeah, but if you have a scenario in which the vast majority of states at the time of the 14th Amendment are criminalizing this procedure in their states, at the same time they are voting on the 14th Amendment, that's not enough evidence to really determine whether or not they thought the 14th Amendment should apply to abortion. I think it's crystal clear, and I think any kind of honest historical analysis shows that there's no reason why you would be voting on something to be a right and in the same breath be voting to criminalize it. It just
Same
makes
thing.
no sense.
Same thing with segregation. But
No, it's different because it's different because in order to ratify that amendment, they needed, a majority, right? It's not like, and there was also a majority of states that were criminalizing abortion. With segregation, you could have had like a minority of states that were like bitching and complaining as they were getting outvoted. That's not the case here. The case here is, if they actually intended for it to apply to abortion, it wouldn't have passed.
So
or maybe the other way around.
You're not denying that there was widespread segregation in public life across the United States during the passage of the 14th Amendment, are you?
No, for sure there was, but I'm not sure there was anything like equivalent to like the actual state laws of Jim Crow until that whole era. I think it was a lot more de facto as opposed to de jure, especially in the northern states, if I'm not mistaken. It wasn't like the state governments like instituting those sort of things. It was really, we saw a lot of the state governments instituting those rules during the Jim Crow era in the South, and the South was the minority of states.
But you would agree that no one thought, regardless of whether or not there was a particular signing statement or anything in the 14th Amendment, no one thought that the Equal Protection Clause desegregated. No one thought the Equal Protection Clause applied to women. No, right? This is just for racial. And what's more is probably mostly black people.
They didn't, but they weren't actively criminalizing it while they were signing it. This wasn't the case, right? So like
you're saying differences, but you're not explaining why that's a distinction with a difference. I mean, yeah,
because it's common sense. Like, I agree. I have to rest some assumption here in common sense that people accept that if you are in one breath voting on a specific constitutional amendment and in the next breath saying this practice is illegal, that practice probably doesn't fall under the right in which the unenumerated right in which that's coming out of this 14th Amendment that you also just voted on. I think that's a pretty safe assumption.
I think that history is, first of all, I would think differently about the history of segregation as applied to black people. Thinking also like a racial covenants and that kind of stuff. And
right back to race.
Well, I think it's a fair example.
So your logic here is saying like if we took that logic, then we would have to have some kind of decision that I don't want. Like that's not an argument. No. That's like the actual process here.
The argument, for those of you saying like it's just consequences, it's not just consequences. The words of the 14th Amendment are equal protection of the laws. States will not deprive people of the equal protection of the laws. That's what it says. And when we sign that into now, everyone starts with a text nowadays. Everyone starts with text.
You start with text, and then you.
Why are you acting like you're the only person who reads things?
Well, because you are discounting the legislative history here, and you're saying, well, the text just says this. I can read anything to mean whatever I want.
What's odd is the fact that most originalists will say we discount the legislative history. We discount it. We read the words as they were written, and we don't worry about.
No, you're actually wrong. No, you're wrong on that. That is like hardcore textualists take that position.
Read Scalia's. Read his.
Okay, so Scalia is not the only originalist. Maybe I have an opinion that disagrees.
Thomas too.
So I don't know what specific. I don't know what specific opinions you're referring to. I'm pretty sure there are multiple cases in which these justices are saying good things about like looking at the intent of the framers of the particular law. That seems to be the whole point of originalism. At least that's the way I was taught it. But I don't know. You can make any amendment read. Like I could read the 14th Amendment to justify bestiality. You could too. Do you agree with that?
No.
Really? You don't think that with liberty, I can't say, well, if I can eat an animal, why can't I fuck it? Explain that one.
Because I don't think that the freedom to have sex with animals is one that's deeply rooted in history and tradition.
But abortion, when they're drafting
the decision whether to bear or beget a child is deeply rooted in our history and tradition.
Obviously, as not as it applies to abortion, because the people that were writing this specific amendment were criminalizing abortion at the same time they were writing this.
That's your failing. Your failing is you view things myopically and at their most narrow. But that's, of course, not the best way to look at these rights or the best way to interpret them at all. If you were to do that,
I just disagree, I guess.
If you were to do that, I mean, you're led to the conclusion that
Brown versus Board of Education, right?
Among others, right? So think also about the First Amendment, the First Amendment. What the hell how do we make sense of the First Amendment? in the context of circumstances that didn't appear before the framers. So what are we to make about what the First Amendment says about, I don't know, Section 230 or Twitter as a public platform or any of that stuff in that moment?
I've already addressed this. I think a better question would be, what if at the like when they were drafting the First Amendment or the First Amendment, they were like, yeah, this probably shouldn't apply to slander. Like, okay, seems pretty fucking clear.
No one is denying that historical practice and what the framers thought informs our decision making. No one denies that. I've never denied that.
And by the way, if they at the same time they were drafting the First Amendment, if they were also like the same people were criminalizing laws, like they're instituting laws criminalizing slander, I would think it'd be ridiculous if like sometime down the road we said, well, the First Amendment obviously protects slander. No, like look at what they were doing at the time of the drafting. Clearly, they don't believe that.
Okay, so I'll give you a couple more hypos then. If there were a criminal law in a majority of states that, I don't know, criminalized publishing a certain like religious material or criminalized, I'm not sure, some political movement or something, you would say the First Amendment doesn't apply to that specific political movement or to that specific religious text where there was a majority of states having ratified that amendment, having criminal laws against those practices. Even though the First Amendment says Congress shall make no law abridging the freedom of speech, the fact that there were laws in those states doing that, you would say is dispositive that the First Amendment doesn't reach those activities.
Likely, yeah. If they're drafting the First Amendment at the same time criminalizing this behavior, I don't see how you can say the First Amendment protects that behavior. I would say it's our responsibility at that point, because again, like I said at the very beginning of this, my morality disagrees with what I think the law of America is and what it should be, right? I think it's up to us to fix it instead of relying on bad case law to protect us.
You've already said that. Yeah, that's a nice
bestiality. Yeah,
like that's a nice thing to say that everyone wants more democracy, everyone wants this, everyone wants that. Yeah, understood that you have different policy perspectives. I'm not assuming that you're in favor of school segregation when I bring that up. It's just to show you that like Brown v. Board is one of those seminal cases among others that I've mentioned where we think that we got it wrong. In fact, one of the I hope we'll get to stare decisis at some point. One of the examples, like we overturn stuff sometimes, is pointing to Brown v. Board and Plessy. And so, like, I don't. If you're going to reject the notion that rights could exist beyond the circumstances, like, what you have to assume, taking your analysis, is whatever circumstances existed at the time of a particular amendment, 50, the majority, that must be allowed by the Constitution. That's silly. That's not how we look at it. We look at what the Constitution was intended to mean in the sense of its value, in the sense of like, what is this actually doing? That's what Scalia is doing in the Kylo case and in the other cases related to dogs sniffing your property for drugs. That's the act of. I mean, that is what it means to interpret law and to interpret the Constitution.
I'll go further. If the Fourth Amendment, at the time of drafting that Fourth Amendment, they said sometime in the future they're going to invent like heat sensors, and that should be allowed. That's like obviously like that should be something that we allow. I would say the Kylo case at that point would probably be wrongly decided, consistent with my argument the entire time.
Wait, can you repeat that? Sorry.
So if at the time of let's say the heat sensors existed at the time of the drafting of the Fourth Amendment, and like they were legalizing like heat sensors at the same time they were drafting the Fourth Amendment, I would say like Kylo would probably have been wrongly decided if the historical facts pointed to that being the case, because obviously they didn't intend for that to be the case, and no reasonable historical analysis would lead people to believe that's what they meant. Unlike the current case in Kylo, which is we have a new technology. What would they like? What is this intended to apply to here? I mean, there's more room for analysis there, and I think that there simply is not when you have again a scenario where they're actively criminalizing something at the same time as they're passing this amendment.
Is it significant at all to you that these abortion laws didn't come into being until the mid 19th century?
They were actively coming into play. Like I think you've already agreed multiple times
in the mid 19th century. The first one is within 1820. I think Connecticut was one of the first ones in 1820.
And likely, really, before the 14th Amendment and before Roe, for sure.
Yeah, so it doesn't matter what happened near the founding of the country?
I mean, clearly it wasn't very deeply rooted if like they just all started switching it.
Well, you agree it's part of the common law,
Well,
or do you? I
yeah,
don't know.
well, sure. I mean, Alito has some analysis of like the common law. I sort of think that part's maybe a little bit weaker. I mean, we can talk about like quickening and stuff, but again, I don't think that should apply to like when we're talking about at the time the amendment was drafted. I think that is much more controlling than like common law going back to Britain about
I mean, that's nice.
a scientific misunderstanding of
Okay,
like
great.
when movement begins, because
So
and the current evidence shows that like fetal movement begins at about 6 weeks. At the time, the mother could only feel it at like 16 weeks. So like, oh, that's obviously like when the baby starts moving, but that's just like scientifically incorrect.
I think it's pretty ad hoc the way you use his history. Like the history that you care about is the only history that matters. I'll throw you one for the Second Amendment. Around the time of the 14th Amendment, you would agree the Second Amendment does not apply to the states until the 14th Amendment, correct?
Like I'll have to double check that, but I'll take your word for it. That's my understanding of what I think is the case.
Well, it was just recently incorporated as applied to the states in
Right.
2010 in the McDonald case. But
Right.
my question for you is like, if there were evidence of state laws which totally banned the usage of like arms in public, or banned the public carrying or even concealed carry at the time of the 14th Amendment was passed, you would agree that the Second Amendment should be interpreted in such a way to not embrace an individual right to concealed carry or public open carry in public, right? If there was evidence of those laws being in place in, say, Texas or New York.
No, I think a better understanding would be like if while drafting the 14th Amendment, they all said, like maybe even if they didn't put it in, if they all said like, yeah, this probably shouldn't apply to the Second Amendment, and at the same time, like they were criminalizing criminalizing gun laws. Yeah, I guess you could probably like look at that, just as whether or not gun. The only problem is now we're talking about like a state by state basis as opposed to like a federal sort of overarching amendment. I'll have to think about that a little bit more, but likely, I think the logic stands where if you have somebody doing something at the time of drafting, you have somebody criminalizing something, it's generally probably a safe assumption they don't mean for that to be like incorporated in with the amendment that they're creating, likely.
And I think it's a generally safe assumption that at the time of the passage of the 14th Amendment, we didn't think that we were going to be applying every single right to the states. And so I don't understand why you're okay with those implied rights if there's nothing explicit in the Constitution which says that you can apply them to the states. You're reading them into it and into like what the value is of the 14th Amendment. You're saying that the 14th Amendment was meant to bring the states into a common kind of like, I don't know, stature with the federal government to put people on even
rights. I think so.
Okay, but you haven't pointed to anything specific. Like, at least I'm not asking you for like specific quotes. I'm not asking you for specific things. But like, what's the kind of historical evidence that you would point to show that there was an intent to incorporate the Bill of Rights at the time the 14th Amendment was passed?
Historical activities at the time, the certain laws that were being passed in the states, like the intent of the federal government post Civil War, what they were doing to the states in the South. I think there's like all the Reconstruction, like there's all sorts of things that like you can look at, like, yeah, like this was meant to apply to that, obviously, and they weren't actively contradicting it like they were like in the 14th Amendment when it comes to abortion. Like if they were actively contradicting it,
though, just because.
If they were like, if they were at the same time they're passing the 14th Amendment, they were also passing legislation saying like federal legislation saying like this, like the Bill of Rights does not apply to like the states. Like then obviously it wouldn't be the case.
Well, there were all kinds of challenges. There were all kinds of challenges early on, or late on in the 19th century about the Bill of Rights applying, and it wasn't really until the 20th century that you're seeing these cases start to be applied as against the states. I don't know. I don't think the common practice was back in after the passage of the 14th Amendment to acknowledge that the federal constitution had been incorporated to apply to the states. And what you're doing right now, which is like saying, what was the purpose of the 14th Amendment? I totally agree with that analysis. That's a great analysis. Like the 14th Amendment was meant to bring these states into the fold, to give a more baseline
at the time of creation. Yes.
Yeah, but
3 years after the Civil War.
But that was also that is the kind of analysis we're looking at the purposes of the 14th Amendment and what it meant at a higher level of generality than any particular set of circumstance.
Yeah, I disagree. But I also think this is somewhat of a dead horse because
Okay.
I've explained my logic.
Okay.
One, we're closing in when it comes to time, but I want to hear your because stare decisis I know was one of your
Yeah.
major points, and I wanted to give you an opportunity
Well,
to talk
yeah.
about that.
Sure. So I think Casey is one of the best expositions on what the stare decisis factors are. Among them, workability, reliance, developments in the law, developments in factual circumstances, which is a big reason why the Casey opinion goes out of its way to justify the overturning of Plessy and Brown v. Board, which I guess Lactoid, you'd be against that, and the overturning of Lochner in the 30s. And so I think that stare decisis is extremely important. It's not an inexorable command, but it's a judicial principle that's essential to the law to establish settled expectations, legitimacy of the court, and to insulate the court from accusations of political manipulation and that kind of thing. In applying this to Roe, there has been no inconsistent development of the law.
Besides Casey.
Casey itself, not to the essential holding of Roe.
Right? Of course it did. It completely threw out the whole 3 trimester framework.
That's the state interest analysis. That's not the essential holding of Roe. The essential holding of Roe, which you disagree with, is not the state. And well, I don't know. You probably also agree with the state analysis.
No. This is one of the reasons why I think Roe is a trash case. Like, how does the 3 trimester framework? How the fuck do you get that from the Constitution? And okay, that stare decisis now. There's the weird fucking 3 trimester framework. And then Casey goes and overrules that, and you're saying the stare decisis is super critical when Casey overrules Roe.
The essential holding of Roe is not the trimester framework, and the trimester framework was seen as inconsistent with the development of law as understood in Casey, and not ever really mapping on to the viability standard in a way that makes sense. And so you would agree that stare decisis is not an inexorable command, and that cases are able to clarify or to
or completely overrule.
It's not completely overruling it.
Supreme Court.
Yeah, but do you care about stare decisis? I understand.
I think it can be. I think that if you can lay out
stare decisis matter, yes or no? I mean, why is that not?
Because you're not deposing me. I'm not gonna give a yes or no answer to this, right? When we're talking about whether or not stare decisis is important, I think it's based on a couple factors, right? I think that if you have a trash case, right? I would overrule fucking Wickard. It's horrible. I would overrule Chaplinsky, right? Chaplinsky, what a disgusting case, right?
Fighting words?
Yeah, fighting words. What a ridiculous case, right? I mean, in Chaplinsky, you have a guy who called a cop a fascist, got beat up, and then those are fighting words. You deserved it. What a weird fucking holding that has no basis in constitutional law. It's based on machismo of the time, and FDR's court, which is horrible and evil. But if we
any court that isn't
any court that
disagrees
with me is so I think that if the Supreme Court was to go back and look at that and say, look, we know that fucking Chaplinsky's been the law for decades, but there was no basis at the time. It's just not good law. It's not compatible with our understanding. We're not going to, if you say something insulting to somebody in the street and they punch you, we're not going to find those are fighting words. Obviously not. And that's
an example of a case.
And the historical basis at the time was trash, right? There's nothing there. We're going to have to overrule that. Stare decisis doesn't I don't give a fuck about stare decisis in that situation. Stare decisis by itself is not enough.
When do you care about stare decisis?
Yeah, so I think it's a positive factor, right? So if you have consistent rulings based on some kind of firm ground and firm fundamentals of legal analysis, and then the Supreme Court's constantly deciding this, there's not a huge issue with the fundamentals and the judicial the legislative history and all that good stuff. Then yeah, I would give bonus points if you can for stare decisis.
This is so silly. I mean, the stare decisis only really matters when it's wrongly decided case. Right? Yeah. So.
Well, no. Hold on. I think it's wrongly decided the Supreme Court should be the one to overrule it. I think stare decisis should apply very strictly to like the lower courts, of course. But when we're talking about the one court in the land, which we give the authority to amend their,
That's not what we're
change.
talking about with stare decisis, is that lower courts are bound by upper appellate courts. That's not what we're talking about.
I know, but that's what I'm saying is the only case in which it should be like unmovable, in which it should be extreme, right? I don't want no lower court to overrule Roe v. Wade.
Yeah, I don't want lower courts.
Like,
yeah, that would be. Yeah, I don't want lower courts to do what they did in like SB8 and allow states to just flagrantly violate settled precedent of the Supreme Court. Yeah, I agree with you that absolutely. I do not want lower courts deciding for themselves when to overrule higher courts. But my question, the stare decisis is not about that. It's about a court which has the ability in terms of power to overturn a decision, but chooses not to for prudential reasons. And my question for you is, when are you okay with stare decisis applying to incorrect decisions?
I give it a few bonus points, but again, like every single hypothetical, every single bad case that you pointed to me, what you attributed to me, every single one, right? That was all decided by the Supreme Court at one point. If you're like if you have such a hard on for stare decisis, like where do you get off saying Chaplinsky should be overruled? Where do you get off saying?
Did I say Chaplinsky should be overruled?
Do you think it should be? What about Korematsu putting
like
Japanese people in camps?
Yeah, that should be overruled.
That should be overruled. Okay, Korematsu, where they put Japanese people in concentration camps, that should be overruled.
100%.
That is reversal of stare decisis because they're.
Well, no, it's the factors point against Korematsu, hugely against Korematsu. The developments in the equal protection law all show that what was at issue in Korematsu, that was way too broad. You have a fit issue with respect to the narrow tailoring of that law. The developments since Korematsu have shown that. The factual developments since that, our notion of what it means to be an American, and everyone's collective total shock at what happened there, our recognizing of the Holocaust and what happened in World War II, that all points in.
Do you not have the same shock about Chaplinsky?
Not as much as Korematsu. I haven't really thought about Chaplinsky a lot before this. I don't agree with Chaplinsky. I don't agree with
you think
obscenity.
Sure, it's a wrongly decided case. Do you think this wrongly decided case should stand on the basis of stare decisis?
I haven't thought a lot about how the factors would apply to Chaplinsky. If I'm just thinking out loud,
and that's fine. In the same way,
I thought a lot about it for Roe. I thought a lot about it for Korematsu, because those are the examples that people bring. I thought a lot about it for Plessy. Chaplinsky is like an area of unprotected categorical, First Amendment speech, which is not the usual cases that people bring up when applying stare decisis. And I'm sorry that I haven't really thought about it, or I haven't really visited Chaplinsky. From my understanding, is that ruling hasn't been reaffirmed like Roe has. Right? It's a very self-contained universe of cases.
It's been narrowed.
It's been narrowed, in fact. And
because it's trash, by the way. In the same way, Roe has been consistently narrowed.
No, but it's been the central holdings that you disagree with have been affirmed multiple times. The holdings related to individual right to have the abortion, that's been affirmed multiple times.
And
it's not like Chaplinsky.
No, Chaplinsky fighting words has been upheld multiple times. It's just been consistently narrowed by situation in the exact same way Roe has.
No.
Yes. But a fighting words doctrine is still technically good law. How are the cases afterwards not upheld it?
Because it has so little relevance to any of our circumstances nowadays that it's almost like
because it's so
not
narrow.
There.
Because it's so narrow.
But Casey isn't like that. Casey
Casey has bite.
Enough. Casey has bite, and so your comparison to Chaplinsky fails on that basis. Casey still has. You would agree, otherwise you wouldn't want to overturn it. It's still doing stuff. It's still operating. It's preventing 26 states from enacting abortion restrictions.
No, no, it's not the effect, right? Because I think we talked about this beforehand. I am pro-choice up to a certain extent, right?
Yeah. Okay.
In terms of you're right. So
I'm not assuming that you're not.
I want an overturn in the same reason why I want Chaplinsky overturned, because it's bad law, and that's enough.
Then that's another way of saying you don't care about stare decisis. It's another way. You saying that
I do not think that stare decisis is dispositive, and if you do, you have to bite so many fucking bullets on
No, you
every
don't.
horrible case. Yes, you do.
Don't. You can distinguish these cases by applying the stare decisis factors, but people just ignore it and put their blinders on and will write stupid YouTube comments and be like, Plessy versus Ferguson, without thinking about what the court said in Casey, and that it's not in Casey they say it's not an inexorable command. In Casey, they're specifically talking about Plessy and Lochner and trying to distinguish it from Roe v. Wade. And so you pretending that like, oh my God, Casey is just an aberration. They didn't even consider about Plessy, or they didn't consider Lochner, or they didn't consider these cases. No, there are factors. You apply the factors. One of the factors is, was it egregiously wrongly decided? I don't think that Roe versus Wade was egregiously wrongly decided. I think that there are issues with Roe v. Wade in some ways. I think the trimester framework is one of them. And I want to address that point about the trimester framework.
Okay,
Yeah,
you can in 1 second. I mean,
Okay.
you would agree that the leaked Alito opinion does go through the
yes,
stare decisis analysis and comes to the conclusion that it's not, the stare decisis is
they
not
go through the
dispositive.
analysis, but it's a bad analysis.
You disagree with the analysis. Sure. Okay.
Yeah, I mean, just like you could disagree with originalist views. You could see Dred Scott in some sense as also an originalist opinion.
No,
you can see it that way. Yeah, you can. Yeah, you can.
No. Yeah, you
can.
Dred Scott is universally condemned. There is no originalist basis for it. Again, I went through the historical
You
analysis.
disagree on their historical assumptions and on their originalism.
No, it literally ignores history. They ignore the fact that there was black freedmen citizens in the country that owned slaves. That's not brought up once.
That's not dispositive. They're not saying that. They're not saying the Constitution demands that people be enslaved. What they're saying is the Constitution.
I never said it did. I never said it did. What I'm saying is
the existence of free people, free blacks, is not
that were citizens. That were citizens.
That were citizens of their state. That were citizens of their state. The existence of free.
I'll look into it. I'm pretty sure they were citizens of the country, but I'll look into that.
You tell me. I mean, before the 14th Amendment, how do we know if someone's a citizen of the United States?
Yeah, I guess.
So the existence
regardless, though, at the Dred Scott decision, right? They did an historical analysis that ignored the fact that black people were citizens. There were freed black people who were citizens who owned. There were some black people who owned slaves, and they completely ignored this history when they came to that decision. An originalist would say, okay, like you have no legislation to point to, you have nothing to point to, and your historical analysis is trash.
You have the entire institution of slavery as it existed throughout, not just by the way in the South, in the almost the entire country.
Yeah, and by the way, yes,
one of the biggest holds of slaves in the entire Union at the time.
Yeah, I know, and the laws that permitted slavery did not say that a black person can't be a citizen. Okay, and they didn't say they couldn't be a freedman. It didn't say they couldn't.
That's what abortion people say. It's like that no one said at the time of the founding that you couldn't have an abortion. And you guys would be like, well, it didn't give you an affirmative right. That's what Alito would say. It didn't give you an affirmative right to abortion. Is there any case law that says that you had an affirmative right? And so like I don't understand.
Because they're using Dred Scott to say like you can't be a citizen. That's what they're saying. You cannot be an American or you can't be a citizen because you're black and because like of this faulty historical analysis. It is an anti-original. Hold on, I do disagree and you disagree too. I'm not saying that. I'm not. Yeah, of course. I'm not saying no sane person agrees with Dred Scott versus Sanford.
I would say something about Brown. No sane person disagrees with Brown.
Sure. But. Well, I'm talking about like on a moral sense and also like in a legal sense.
I agree.
Dred Scott versus Sanford is not a original. There's no originalist argument. There's really no argument. It's a trash case. Like
you
no matter
which way you look at it. It's not an originalist argument and just like deny that what the court is doing is looking at like original intent.
Okay. No. All right.
But like, that's what they say they're doing.
Okay. In my opinion, which I'm here on this show to give, I think that there's no originalist argument.
Okay. So just like Alito can have a different application of, just like Dred Scott, in my opinion, not in your opinion, in my opinion, can have an incorrect application of originalism as viewed through the history. Alito, in my mind, could have an incorrect application of stare decisis factors. I'll just summarize again because we only got through one. Sure. I don't think that there's been inconsistent development of the law, certainly not to the same level as Shaplinsky or some of the other cases that existed, or the Korematsu stuff. I don't think that there has been a unworkability. No, come on. At least not with the central holding. At least not with the central holding about no abortion bans after viability. That's not unworkable. And as far as the undue burden line, or that analysis. It's just like any of these analyses. Courts develop them over time. Courts will offer their, through case law, just like reasonability, just like all the First Amendment cases. It's not like 100% clear at the time that these seminal cases are passed what particular practices are going to constitute undue burden, what particular practices count as viewpoint discrimination. But you develop it over time. That's what case law is. And then finally, there's been a huge reliance interest on the holding in Roe and the holdings in Casey. And so for all those reasons, I think it's a clear, very clear application of the stare decisis factors in favor of maintaining it. But I don't even know why you would care about stare decisis.
Yeah, no, I'm super skeptical of it. I think if it's terrible law, just because we have if we have incorrectly decided bullshit, I don't think we should be stuck with it. I also,
so Brown should be overturned, right?
So, man, again, so you went to the factors.
Brown was egregiously decided.
No, I know what you're doing. I know what you're doing. So, to the person who thinks stare decisis is decisive, and you think that again, Plessy versus Ferguson, right? Oh, that's protected by stare decisis. Now you're going to go through the 5 factors.
Well, I'm applying. You want me to apply?
Yeah. Well, I mean, I could apply the 5 factors, and Alito does apply the 5 factors, right? You gave your arguments against why you don't think the 5 factors apply. I'll talk about why he does. For Dobbs, the new case against Roe, right? So why he thinks that stare decisis here should be overruled. I've got a quick summary. My understanding is that the nature of the error, it was egregiously wrong. Usurped the democratic and social progress that was already underway at the time. That's historically undebatable. Quality of the reasoning. I know you don't. Quality of the reasoning. There's a lack of precedent. That's just true. Erroneous historical narrative. That's true. Concocted an elaborate set of rules, such as the 3-trimester framework, with different restrictions for each trimester of pregnancy, but did not explain how this veritable code could be teased out of anything in the Constitution. Okay, so the quality of reasoning, I would argue, and Alito, I think, correctly argues is shit. Workability of the rules is imposed in the country. Viability is arbitrary. Viability depends on nothing to do with characteristics of a fetus. One is a state of neonatal care at a particular point in time. The viability line is therefore changing over time and changing with how our medical technology advances.
That makes sense, right?
Undue burden is meaningless and not a cognizable standard reflected in sound constitutional analysis. Again, we're talking about workability. It seems to be incredibly arbitrary, and when we're talking about a controversial issue such as this, it does seem to have some issues of workability as you go state to state. Disruptive effect on other areas of the law. We're talking
what
about.
You're doing is disruptive. You want to get rid of Lawrence. You want to get rid of. Griswold. You want to get rid of all these cases.
No.
That's disruptive.
Right. I'm just talking about Alito's reasoning as to the 5-factor analysis here for stare decisis. Right. Harmonized standards for facial constitutional challenges. Undue burden standard is unique to abortion versus the rational basis or strict scrutiny that you were talking about before. I mean, I've always thought rational basis, strict scrutiny, and intermediate scrutiny were also somewhat arbitrary. But at least when you have those, you have one set standard as opposed to undue burden, as opposed to undue burden, which is way out of fucking left field. Again, disruptive. And then the last one. I just want to hit the 5th one because you had an opportunity to talk about the 5 as well. Absence of concrete reliance. Abortion obviously occurs from unplanned pregnancy and is inherently not a reasonable reliance interest, as argued by Casey. These are the factors that were pushed by Alito in his Dobbs decision. I don't place a super heavy weight in stare decisis, so I think that these arguments are pretty convincing, at least to overcome what I would consider to be a relatively low threshold to overturn a poorly decided case.
In response to a lot of that, one is the question of arbitrariness. How can you have this line that's just viability? That is not a problem with respect to state interest analysis in so many other parts of constitutional law. In constitutional law, we have to draw lines somewhere. You would agree, Lactoid, that at some point, some level of encouraging other people to do criminal acts should count for incitement, right? You wouldn't think that there is this absolute immunity for your words to ever cause criminal or ever be criminal conduct, do you?
I'm not disagreeing that we can draw
Yeah.
lines, but what
So-
Alito was arguing is this specific undue burden test, which is unique for abortion, is disruptive to all the other set
Well, let's
standards
talk about
and
the
calculations.
let's talk about arbitrariness first. Arbitrariness first. Is it somewhat cosmically arbitrary to say that the line is for incitement is like imminent, right? That's one of the lines for the Brandenburg test, and it has to
Well, at least a factor that we're considering, right? When it comes to abortion, like if hold on, if there comes to abortion, if there was like on the 3 trimesters, if there was some kind of like happening at the time of like the end of the first trimester, and some kind of happening at like the end of the second trimester, like at least you have an argument. There is no reason for the 3 trimester framework.
Is there a reason for incitement to be where it is? I mean, why not go before Brandenburg?
I mean,
why not?
I think there is a reason, right? Because like we allow speech with exception to like when these specific things happen, and here's why.
Yeah.
Right, and
Yeah,
here's like, why, because of the effects and the nature of this has these effects, right? So when we're talking about a first trimester,
that's policy, right? That I mean, what you're talking about sounds like very
policy is important.
Prudential and political, like policy, not political. Policy and prudential reasons why it's there. It's there because we don't want to chill speech before it. It's there because we will be able to know it when we see it, when it's like right about to happen. It makes sense for it to be there. These are all prudential and policy reasons why it makes sense for the line in Brandenburg to be where it is. Likewise, we all agree that there's limits on the abortion right. No one thinks that you should be allowed to like literally kill a 1-year-old or to kill a 5-year-old and or to kill without restriction.
What if the 3 trimester framework? Right? Well, I know. What if the 3 trimester framework said like the first trimester is like pregnancy, the second trimester is 1 year old.
Well, I think that it's okay that Casey overruled the trimester framework.
Because it's okay. Hold on, that's an overrule of stare decisis. You would agree?
Yeah, but for reasons related, first of all, the trimester framework not being the central holding of Roe, in my opinion.
Okay.
The trimester framework being undermined. Yeah, it was a trash. I think it's a bad finding of Roe.
And the topic of this debate is Roe v Wade.
No, but Roe v Wade's essential holding is correct, and Roe v Wade's essential holding is good, and it's the reliance gendered and what it does for our society is good, and it should be defended, if for anything, to defend our judiciary's legitimacy. But that's the topic, not whether or not the trimester framework itself was a good decision of law. I don't think the trimester framework makes much sense from my perspective.
Look, I will not bring up the 3 trimester framework again. I mean, because it sounds like we both, as long as we both firmly agree, like that 3 trimester framework, it was just trash. Like it was just bullshit. Like it was purely political hackery.
No, I don't think that. I think it was.
No, you don't think so?
I don't think that it was hackery. I think it was a way to try to approximate the lines that made sense from an interest perspective. But it just kind of doesn't. We should have a unified view of this, right? I think, as opposed to one which kind of sets the first trimester date, second trimester date. There should just be one date of interest, which is the viability line. That's what makes sense. And to put these other limits there, to me, is kind of not really grounded in any prudential reasoning or any policy reason that makes sense.
I'd like to ask you one more question. Let's say in the future we get technology that's so good. That,
it goes back. It goes back.
Yeah, so like, let's say it's so good that
sense,
like immediately when the egg gets fertilized, like we can pull the egg out and like put it like in a machine, and then it grows into a person, and then now you're responsible for that child.
It makes sense that the state's interest would crystallize at that point. Yeah, but it's a state's interest analysis that is looking towards when it's okay for the state to put restrictions on abortion. That's totally fine. The line would move. That's Casey's opinion talks about that. It's not like some anomaly. Lines will move with respect to states' interest. Think about national security interest in the context of overcoming some strict scrutiny analysis for, I don't know, an explicitly racial-based classification or some kind of imposition on people's right to travel, let's say in COVID stuff. If COVID started going away, you would agree that it would be a harder to apply the factors related to compelling purpose, and the state's interest would become lessened. That's not an anomaly in our law, and so it's not it's not weird that line would change as circumstances change. It's just acknowledging that state's interest can develop and change over time.
Well, I want to say though, the reason I asked that is because I think it will present a interesting conundrum, because when you look at the political support for abortion and you look at the look, like the people who support Roe and the people who get abortions, the polls on the motivations behind it really don't have anything to do with this kind of concept of like bodily autonomy, and everything to do with this concept of like, I'm not ready to be like a mother yet. Like it's like in terms of like poverty. I've seen the polls, like that can be a discussion of a different time, but I do wonder if we get to the point where we can like extract a fertilized egg and like, okay, grow it into a child, and now you're responsible for taking care of it. I mean, I think that would undermine the purpose of abortion for like the political purpose of abortion for a lot of people. And so
the political purpose,
the purpose of abortion for a lot of people, the reason they support it politically, I think it would undermine that.
The same can be said of the Second Amendment. I mean, people will take up gun ownership because it's fun. People take up gun ownership because of self-defense. And I would say, like, of all the people who take up gun ownership, I'm not sure that the majority is to support the militia, which seems to be, at least, even if you respect an individual right to have guns and to keep and bear arms, it seems to be like heavily implied from the Second Amendment. You would agree with this. The heavy implication of the Second Amendment is not personal self-defense, but to defend the against the government intrusion or to defend the militias. And so just because a particular segment of the population has certain reasons for wanting one right over the other, doesn't necessarily mean that somehow we shouldn't rely on the actual constitutional foundation and rationale as opposed to the policy reasons of individuals.
Right. I'm not saying we shouldn't. That was just an aside. I'm just on my curiosity and how this position would advance.
To be honest with you, I want to address some of the other things you said in that. So what you just said.
Would you Prime? Would you give us 5 more minutes? I have to use the restroom very badly.
Okay, go ahead.
I really have to piss, and so, but I don't.
I have no specific time. Like I need to drop off, so you need to go a bit longer or not. That's up to you two. I'm more than willing to host if you want to.
I won't talk for the benefit of not being unfair to him.
Really? I'll take pot shots at him. I mean, fuck. Do you see his hair today? But this has been super exciting. Your discussion.
Yeah, I gotta say, I'm not totally. I'm still like floored with some of the bullets he was willing to bite, but we can deal with them.
Okay. Something to occupy the audience with. We'll be doing all black everything, guys. Oh, guys, you guys want to support? Hit that follow button if you've just found this channel. Hit the follow button. And follow us on social media, / social and chat. Support this channel. Support the content. Twitter is where you'll find updates when we tell you what's going on. Discord, where we do everything. Jump into our Discord, and YouTube is where you find the VODs. If you missed anything, head over to our YouTube. Like, comment, subscribe. Also, if you want to help out, consider subbing to the channel. $5 helps us out a ton. $5, okay? Helps, and of course you get after viewing and all that good stuff. You get our emotes, or subs to the channel, gifting bits, gifting subs. Thank you for the resub, Sweatpants Freedom, $5 a month, for 10 months. Hey, means a lot. Thank you, Sweatpants Freedom, for the phone. What else? Yeah, I guess that's it. Antidepressant says, can you ask Pisco why Wickard was properly decided on constitutional grounds?
Yeah, I can. Yeah.
I want to hear that.
Sure. Can we finish the abortion discussion, then we do a little Q&A about all the other cases?
Okay.
Or do you want me to do it right now?
Well, we could do that, but you gotta promise me on your word, on your pledge to the Bar Association.
It's a hard case. But I think
that case single-handedly makes me.
It
keeps me up at night. I'll say that.
It's a hard case. I'm not gonna say it's like an easy one. And there is like a question of what are the limits of the Commerce Clause after Wickard? And I think some genuine criticism of are we even a government of limited powers anymore? But I can get into Wickard in a bit.
Great. Thank you.
On the abortion stuff, let's take a stock of where we are. And you tell me if you disagree with me at any point with my summary of what's going on. It sounds like you're very much interested in an approach to constitutional interpretation that focuses on not so much values that can transcend or at least overcome the particular social practices at the time, and focusing on what were people doing at the time the provision was enacted, what particular things were they doing, and to what extent can we suss out their intent, the specific intent of the people who were there. And that's been your kind of approach. And in doing that, I think you've been honest, at least in acknowledging that a lot of the cases that Roe relies on have to go away under that approach. Griswold has to go away. That's contraception. Lawrence has to go away. Maybe some of the sterilization cases go away. Brown v. Board goes away in terms of
maybe, yeah.
Yeah. I think from my perspective that I see the value intrinsic in some of these constitutional provisions as being more elastic and embracing at one level of generality removed. So it's not about abortion itself, where I agree abortion was criminalized, at least many kinds of abortion, at the passage of the 14th Amendment. I agree at the turn of the century, it was criminalized in almost every state. Though I acknowledge that there's the common law seemed to be okay with abortion pre-1820s, 30s, 40s, 50s going into it. I'm looking not at abortion qua abortion. I'm looking at the decisional autonomy of whether to bear or beget a child as relates to your right to order your family, the intimate decisions about who you are as an individual with respect to your family. That's how I view the right. And that's why I think we end up differently in our outcomes there. But
so
isn't your perspective?
Well, it seems a little bit like you gave a little bit of like a conclusion, but if you're not, I'll let you follow that up with whatever question. But
No.
I would like to. I mean, you explained my position, but obviously it was in the lawyer lens of the opposing side. And I mean,
this was not meant to be my closing, but
sure, okay.
We can do closings at some point soon. Isn't your position under your position? Isn't it the case that you're asking the court to overturn more than Roe? You're asking the court to take a radical departure from its precedent. Not because substantive due process, even Alito acknowledges that it's the law of the land. But you're asking the court to take an even more radical step, which is overturning all kinds of precedent. At least, be honest with you, that's what you're asking the court to do.
Sure. So first thing, my hair is beautiful, Prime.
Okay. Oh, you heard everything.
So yeah, don't appreciate that. Second of all, yeah, for sure. I think that they're, I think there's a lot of laws generally that I disagree with, right? And interpret like Supreme Court rulings are law to a great extent, and so yeah, I think that the justification for a lot of these opinions is bad. I think that if we can reasonably claim to be a democracy, we can't have a panel of unelected judges making leaps that go to like
that's Marbury though. That's
the ridiculousness.
You can't say that. That's Marbury.
I understand, but Marbury didn't say the Supreme Court can do whatever it wants and interpret it. For Wickard can make the federal government be able to do anything regardless of anything.
We'll get to
Commerce
Wickard.
Clause.
We'll get to Wickard.
Yeah,
but
so the Supreme Court. Yes, that was not the intent here. Okay, my understanding here is that we're a republic, and democracy needs to be limited. Of course, I'm strongly in favor of expanding the Constitution. Of expanding the Constitution, of expanding the Bill of Rights, of making sure that we don't suffer the tyranny of the majority. But at the same time, right, we have this democratic system in place as well, right, to counteract that. And when you have a situation like in Roe, in which you have such at the time of the passage of the 14th Amendment, you have such an overwhelming democratic push to one direction. And then 100 years down the line, this panel of judges decides, well, we know what they thought better than they did. I think that is the epitome of arrogance.
Why accept that framing? Why accept that your way of looking at the law is the only way that we should look at the law? I mean,
why accept that your way of looking at the law is we're obviously arguing for our positions here.
Yeah, I understand, but people might reasonably disagree with the notion that we should be limited to the specific circumstances that existed at the time of these amendments, because to do that is to ignore, I think, the most basic principle of the Constitution, which is to have a union that endures, to have a union that lasts, and to have a Constitution that makes sense given our times. That doesn't mean that you can read the age requirement for president of the United States in Article 2. Is it Article 2? I think it's in Article 2.
What if our definition of years changes? You have, of course you could.
I don't think that would be a reasonable interpretation.
Why not? Right? Let's say over time, like let's say the sun changes orbit. And all of a sudden
if the sun changes orbit, then we can have a discussion, okay? But in terms of
no, we can't.
Yeah, we can.
No, if the sun changes orbit and like the 4 seasons get shorter or whatever bullshit, like 35 years should mean like what it meant 35 years.
If we change orbit, what a day means is different, right? A day is defined, right? Do you agree with that?
No, I would say it was a day as considered at the time. That's what I would say. If let's say climate change happens and like the cloud cover changes or whatever, and like night falls sooner or whatever bullshit, the criminal statutes like outlining like statute of limitations, they should not change based on like the weather. No, it should be
isn't a day a rotation of the planet? Am I crazy?
Well, it's based on the rotation of the planet, but a day is whatever we said it was.
I feel like I just said something really stupid with respect to.
No, you're right.
It's the rotation. It's the rotation.
Okay, it's the rotation.
I was talking to a day. Yeah.
If it starts going faster, right? If the planet starts spinning faster, isn't a day shorter?
So you think that if the world starts spinning faster, our statute of limitations for like the poor sap that was there when the Earth started spinning faster, that should speed up? No, of course it shouldn't.
All I'm saying is that it's like a conversation that we could have about like what days mean. Like maybe we will have to like.
It should be legislation.
Think about this though. Think about what you're saying, right? You're acknowledging that 35 years will mean something different now, and we're going to change what 35 years means based on that, right? That's okay.
Yeah, I understand that. No. We're going to look. No, that's not what I'm saying. I'm saying we're like, if our definition today changes of what 35 years is, right? We should like go back to like what was the definition of years at the time of drafting of this particular thing, and if it's like 365 days. Yes.
I don't disagree with you, because for my money, the 35 years, that isn't meant to be an area where it's not supposed to be a term that's elastic, like equal protection, due process of law, or cruel and unusual. Those terms, even if you accept your framing, I think those terms were meant to be, the reason they got support in the several states isn't because they were specific, it was because they were general. They were general, and everyone knew that they were general. And when they were passed, the states couldn't have said, well, this provision is codifying everything that the majority of our societies are doing. That's not what people thought that those things meant, I would submit to you. I think that those values, there are certain key terms: liberty, equal protection, due process. Those terms, cruel and unusual, those terms are meant to have an elasticity and to represent a value that transcends particular circumstances. That's not the case in 35, right? It's not the case in the impeachment clause. That's what I'm talking about. And I'm okay with that reality. And I think, what's the point of any judicial philosophy? At bottom, it's to have, over the long run, good outcomes for our society, to preserve our society, to make it stronger, and to make it endure, to make the union last. That's what at bottom our judicial philosophy is about. And if your judicial philosophy is consistently incompatible with the times, even Justice Scalia said the amendment process is way too hard. If you could change anything about the Constitution, it would be the amendment provision, but that's never going to change. Why limit yourself? Why have a judicial interpretation that limits these value-laden words to the particular circumstances that existed at the time of their enactment? That leads you to all sorts of bad places. And I'm not saying that in any individual case, the circumstance should be what dictates the outcome. If I said that, I would say something like the drug war is unconstitutional. I don't think the drug war is unconstitutional, at least not from an individual rights perspective. Maybe maybe you agree with Justice Thomas in Gonzalez v. Race and that sort of thing. But I don't disagree with the drug war as being unconstitutional. But over the long run, your interpretive philosophy, I think, doesn't lead to a robust constitution. And you can have a judiciary that's tailored to and not uber political and taking power, and not totally devoid of any reason, even notwithstanding the fact that you have value-laden words that match changing and evolving circumstances.
Okay. Well, I'll agree with one thing that you insinuated, or I think even directly said. I do think your rationale here is outcome driven. I do think that the rationale of the people of your understanding of the Constitution, and which, I mean, there's obviously, we're both scholars of the law. There's room for disagreement, but I do think that yours is a lot more outcome driven than mine, and I think mine is a lot more rule based. It's more deontological.
But it's deontological to like circumstances, you know?
Sure. I would like to take this time. We could just do closings on the Roe topic, and then you have to answer. And then you have to answer.
Do Wickard first, or close on Roe first?
Let's close on Roe, and then you have to answer Wickard, because that gets me angry, right? Roe doesn't get me angry in the same way Wickard does, because Wickard. Okay.
I just monologue. Do you want to start? Do you want me to?
Yeah, I'll just. Okay. You gave your opening first, and so I'll let you get the last word.
Okay.
At least in the closing with Roe v Wade. You know, I agree that my understanding of constitutional analysis is not as elastic as Pisco's. I think that you can have some elasticity again, but you know, I want to go back to what we had talked about, and the point that I made, you know, early on in the discussion, right? Where, you know, if at the time of the drafting of the 14th Amendment, the people who were drafting it wrote down, you know, hey, look, this does not apply to abortion, right? Pisco agreed that if that was the case, I mean, it'd be a very difficult argument, Roe v. Wade. Now, I would argue that when you have people who at the same time as drafting the 14th Amendment are criminalizing an act while they are drafting this 14th Amendment, I think it is, any kind of honest historical analysis makes it crystal clear that this is essentially the same thing. They are saying we do not intend for the 14th Amendment to apply to abortion, because it makes no sense otherwise for you to be passing the 14th Amendment and drafting it and passing it at the same time in the same era as criminalizing, the same lawmakers as criminalizing abortion. I think that stare decisis is one maybe where I'm more flexible, and where Pisco is less flexible is when it comes to stare decisis, right? I think that stare decisis is by itself a poor reason to maintain bad law. I think that there's no reason why our children should be beholden to the mistakes and shitty reasoning of what I would consider to be activist judges, right? You know, for the longest time, for example, right, burglary, it used to only apply at night. But we realized this was ridiculous, right? And there wasn't actually like any basis for it. So there wasn't any real reason why we couldn't change it. You know, we're talking about Chaplinsky, right? That hasn't been formally overruled. That's the case which said that if you call a cop a Nazi under Chaplinsky, you know, you've engaged in fighting words, so you can get your ass beat. Obviously, this contradicts the First Amendment. Obviously, it contradicts what it means to live in a civilized society. Just because it's been around for 70 years, or however, I'm pretty sure it's been a little more than 70 years, doesn't mean that it's that it's valuable. It's not a valuable case. It should be overruled. Wickard should be overruled. We'll talk about that in a second. Korematsu should be overruled. Yeah, you can't put Japanese people in camps. That's wrong. And it's constitutionally wrong, it's legally wrong. And so, you know, ultimately, I think that the law should be about setting up consistent rules and legislation for society that doesn't change as a bellwether with, you know, the political zeitgeist of the time. Because, you know, while you may agree with it in Roe, and you may agree with it in Lawrence, and you may agree with it in Obergefell, you know, there are cases in which you won't agree with it, like Korematsu or Chaplinsky. There are cases in which you won't agree with it, and those cases may come up again in the future. And if history serves us right, they likely will. And so I just want to discount this framing of I'm evil, and I wanted to more frame it along the lines of this is a legal procedural disagreement. We both agree that a lot of this stuff should be law. I just think that it should be codified, it should be made clear, and we shouldn't have to rely on what I consider to be bogus interpretation and bogus rationalization to do Congress's job for them. And then I'll let you give your closing, Pisco. Thank you.
Yeah, thanks, Lactoid, being a good sport and letting me just like hit him with Brown v. Board over and over and over again. And thank you, Prime, for hosting. It's a lot of fun. In summary, yeah, I'm going to call Lactoid evil, somewhat in jest, but somewhat not in jest. I think that what he represents is truly a radical departure from recent Supreme Court precedent and also from the draft opinion of Alito. Lactoid is not just telling you that he wants to get rid of Roe v. Wade. He's explicitly telling you that he wants to get rid of all those lines of cases. That's the contraception case, where it would be constitutional for a state government to tell you you're not allowed to buy a condom or possess a condom. He wants to get rid of Lawrence, where the government says, we're allowed to criminalize homosexual conduct in your bedroom. That would be constitutional. He disagrees with, I'm going to hit him one more time, with the holding in Brown v. Board, among others, where it would be constitutional for a state government to enact segregation in the United States of America. And all of this is based on, I think, a misreading of the Constitution. The Constitution is not, especially the provisions dealing with individual rights, are not prescribing a set of individual circumstances, except when they do by their terms. They're setting a bunch of values. Congress shall not abridge the freedom of speech. Congress shall make no law depriving the people of their liberty to keep and bear arms. No unreasonable searches and seizures. These terms don't define themselves. No cruel and unusual punishment. And what we know from history and what we know from the mere fact that a group of states would choose to enact these statements is that people agreed with the value, but not necessarily with a set of circumstances that existed in the 18th century or the 19th century, or whenever they occurred. It happened to be the case. And he doesn't disagree at bottom, I think, that the Ninth Amendment seems to imply some exercise of finding implied rights that aren't explicitly enumerated. His version of when you would find those implied rights are a little bit differently. He would, agree with the incorporation, maybe not solely on the due process clause. Maybe he would incorporate the privileges or immunities clause. Maybe he thinks it's implicit in what the 14th Amendment textually reads. I think that's a bogus reading of the 14th Amendment if you think it's explicit, that it constitutionalizes, as applied to the states, all the Bill of Rights. But he agrees at bottom that what we're doing is we're finding some implied rights. He just disagrees with the method in which we do it. Do we look to the values or do we look to the circumstances? And I think that a much more robust view of these rights is not as the set of circumstances, but as what are they getting at? And so the decisional right of an individual to bear or beget a child, that's what we're looking for. And that's why he wants to protect that, at least with respect to the government forcing abortion, as he told you that he would be against it. He would say it's unconstitutional under a Fourth Amendment theory. Maybe we'll give him time to develop that, because I kind of just sprung it on, although it was in the Casey opinion, that hypothetical. There is this notion that there are certain rights that are not enumerated in the Constitution that we all accept. And that's what the court did with sweeping super wide majorities in the line of cases in the 20th century. And that's what he wants to get rid of. And he wants to get rid of it despite the fact that it's been affirmed numerous times. I'm not saying that stare decisis is an inexorable command. Dred Scott was wrongly decided the day it was decided. Plessy versus Ferguson was wrongly decided the day it was decided. Korematsu was wrongly decided the day it was decided. Chaplinsky was wrongly decided the day it was decided. But these cases are not opposite, because the factors point in different ways. The factors point in different ways for the following reasons. In Plessy, in Korematsu, in Lochner, factual developments showed that the factual assumptions that these cases were based on just weren't true. And we couldn't live in a world where contractual liberty in the face of the Great Depression was a substantive due process right. It just didn't fit into what our country was about, what we learned through experience. and it wasn't in concert with what we found to be intrinsic to ordered liberty. Same thing with Korematsu. Our knowledge over the time, since Korematsu came to be, has been that we need to have more robust protections for racial minorities and national and ethnic minorities, and that the law at the time, it was way too broad. Legal developments since then have shown that that rule was way too broad, and it's undermined the decision. Chaplinsky constantly narrowed such to the place where it's almost not even a thing anymore. Like, it's hard for me to even think of like recent cases where you're applying fighting words. Not the case in Casey and Roe, where this has a rule with bite, and it's been affirmed numerous times, and there has been no substantive on-point precedent that like brings it into question, or factual developments that change abortion. That's part of his argument, is that abortion existed then and exists now, and there is no factual discrepancy. And to say kind of in conclusory fashion that, well, the reliance interest is not concrete, that's just following Alito's invitation to tautology. It's not concrete because it's not concrete. And so based on I think the substance of the implied right of abortion as developed in the 20th century and as seen in the other contraception cases, other cases related to due process, Roe has a strong foundation in law. And it's not this like totally aberrant exercise of finding whatever right you want. It's an exercise of seeing the rights at some level of generality above the circumstance and what they're trying to get at. And it's informed by history, but it's not dictated by the specific things that were going on in the 19th and 18th century. In closing, I'll just say that I think my judicial approach is better. It's the perspective that the court has had in the last century. And Lactoid's approach is not even one that the most conservative members on the court agree with. This would be far, far, far removed from even what Clarence Thomas is suggesting. And that's kind of where I'll close. Thank you so much for the debate, Lactoid, and Prime for hosting.
Yeah. So I'll jump on the screen for a bit, and we'll do that the additional question in a moment. Guys, if you've been enjoying this content, support this community by subbing to this channel. Helps out a ton, allows me to do this, allows me to gather these amazing people and have a discussion with them. $5 sub to the channel. If you have Amazon Prime, says Prime Gaming, use that one free sub per month here in this community. Support this content so I can always provide you with more. We do it 7 nights a week. We're always providing you with something. So if you like what you're seeing, the sub to the channel, give bits or give subs. Remember, if you're subbed, we get our emails after viewing, and you'll be keeping this content around. Okay, so you guys had, well, first, you go first. You were gonna answer that question, and could you tell us what the case is?
Yes. So there's I have to tell you what the Constitution says, then I have to tell you what the case is, or Lactoid, you can.
So you can tell what the Constitution says. I need to describe the case because
okay. He's going to put a spin on it, but I'll put my spin
your ass. I will. Yeah.
Okay. So the Constitution makes the federal government a government of limited power as opposed to the states. The states are assumed to have general police power to regulate whatever they want. And you'll notice, even though the Constitution is taken for granted the existence of the states, no place has established the states because the states predate the Constitution. The United States government is after the state governments. And so the United States government, we understand through the 10th Amendment, and just as a necessity of listing out the powers of Congress, is a government of limited powers, even in the legislation. And in Article 1, and also in Amendment 14, Section 5, and other amendments elsewhere too, there are heads of legislative authority that Congress is given. The most important head for purposes of modern federal legislation is the Interstate Commerce Clause, which says that Congress is allowed to pass laws with respect to interstate commerce and inter-country commerce and between the native tribes. And what that means has been a big source of consternation for the court over centuries, and what the limits of that power are has been a big source of consternation as well. And there's been tons of cases, and Lactoid will tell you now about one of the most infamous ones in the 20th century in 1940 something during the World War II, I think.
Yeah, so I'm going to tell you guys about Wickard versus Filburn. It was decided November 9th, 1942. Okay, so you guys heard about the Commerce Clause, which is where the federal government can regulate commerce between the states and with the native tribes. And so because the federal government is a government, supposedly, it used to be a limited government. There were certain restrictions on what the federal government could do in interfering with activity that took place entirely within the state. And so this guy, Wickard, right? Filburn, Roscoe Filburn, he was growing up a bunch of wheat on his farm entirely within the grand state of, I believe it was Ohio. Yep. And at no point did any wheat leave Ohio. That's an important statement, okay? Nothing went to any of the other states. Everything stayed within Ohio. And he was growing wheat in Ohio. And the federal government said, you can only grow this much wheat because, they like to interfere in everyone's lives. And Filburn said, no, I'm going to grow a little bit more wheat and I'm going to feed my animals with it. And it's not going to leave the state. Well, the federal government, the Supreme Court, decided that by growing wheat entirely within one state, you are still engaged in interstate commerce because that affects the price of wheat in other states because you're not buying the wheat from those other states, which means that the price of wheat over there would go down. And so because you are, and this, by the way, it's not a substantive test, it can be trivial. So if there is any effect whatsoever on the price of anything in any other state, the federal government has the right to regulate the activity that you do in your own state under the Commerce Clause. And that was decided by Wickard. And Pisco thinks that was a good decision. Pisco, defend your insanity. Go ahead.
Yeah. So I don't
And before you do,
yeah.
I want to hear from you guys. We're on a hype train. Thank you, NJ Problems for the 10 subs. Thank you, Desperado Sensei for the 200 bits. Nair Socks for gifting a sub as well. How about the hype train? Support this content, sub to the channel, get bits or give subs. I really want to hear what Pisco has to say because it sounds really fucking ridiculous.
Yeah. So at first it is, to think that essentially wholly intrastate activity could ever be the basis of Congress's authority to regulate interstate commerce. It's intrastate activity. And so how can you find a right to interstate commerce regulation based solely on intrastate activity? Thankfully, it's not the approach that the court has taken or the one that you should take. The particular holding of Wickard v. Filburn is a bad case for people who believe in like a strong commerce clause. They're bad facts, and they're like the worst possible facts because you have like a very sympathetic farmer who's like, I'm just growing wheat to feed my family, and like I'm not affecting, and the government comes to be like, dude, you broke the law. So the facts are very bad, but I don't disagree in principle that in aggregate, purely interstate activity could have a huge detrimental effect on interstate commerce in a way that Congress should, of course, be able to regulate. For instance, if suppose that you just had intrastate activity where, I don't know, you're developing a drug market intrastately for some kind of narcotic or fentanyl, and you're selling it just to interstate residents. And in fact, you're telling them you're not allowed to take it outside of the state. Occasionally you're enforcing it, but the end result is just constant amounts of drugs are flowing interstate between the several states in fentanyl. And it's affecting interstate commerce because, people are driving, drug cartels are driving on the road. People are moving all the way to have massive shipments of this like pharmaceutical that exists in this particular state. Notwithstanding the fact that some actors in this particular scenario may be acting wholly intrastate, surely Congress has an interest in aggregate to tackle this evil that is in aggregate affecting interstate commerce. And I'm curious, Lactoid, is there any limiting principle here? Just because all the individual actors making up the evil or some large segment of them might be acting intrastately, is it your position that they should never be touched by any law affecting interstate commerce?
Yeah, no, it's in, yeah, okay. The law is to affect interstate commerce, right? It's not to affect intrastate commerce. If you add something else if you want to affect that. But like at the end of the day, I think under the originalist understanding, obviously this wasn't meant to affect something entirely occurring inside the state. B, if we're going off of like Pisco's kind of like values and stuff, he's fentanyl. What's happening with how they're using this is why the DEA is like coming into states where they have legalized marijuana and like raiding people who need to grow it for like their disabilities or whatever, it's medical marijuana, stuff like that. And three, it's patently ridiculous, and because it's not even a substantial test. It's a trivial test, which means it doesn't matter how much it affects state commerce. If it affects state commerce, there's nothing about. If it affects state commerce, it is under the Commerce Clause. I could give you hypotheticals that would be just insane, right?
But the court's kind of turning away from that. I mean, Obamacare decision, they lost on the Commerce Clause stuff. Lopez is another one on the gun control case.
You are finally having some conservative courts slowly eat away at the evil that is Wickard, right? Because before this, the federal government used Wickard to do anything they wanted, right? And they would just say Commerce Clause, and they would win. Because under Wickard when you look at the facts of Wickard, I mean, if the facts apply in Wickard, they're going to apply to anything else, right? If I grow wheat, if I am building a house in one state and like I'm using lumber entirely from the one state, well, it's affecting wood prices. I'm not allowed to build a house now in my own state. But the federal government
maybe the maximalist reading of Wickard would do that, but I think if you understand the context of Wickard, maybe there's some limiting principles there. One is this was at the time of World War II, right? Where there's like a huge price problem with respect to wheat.
It was a bad policy, but it doesn't actually matter.
Sure. Yeah, you can say price control sucks and socialist.
Not only was it bad, for sure it was communist, but it was also bad for like the war effort, right? Like afterwards, they did analyses and like.
But Congress they're allowed to be stupid, people. Right. There's no constitutional provision against doing bad policy. I think you would agree.
Yeah, government is generally stupid.
But maybe the limiting principle would be something like. And Wickard didn't expand on this. Maybe that's why. Maybe I would agree with you that it's a bad reason for that. It's a bad opinion for that reason. Maybe I would say at the very least, it's a bad opinion for not stressing the limiting principles that exist and just focusing on the particular circumstances in front of it. So maybe I'll say that much. At the very least, I'll say even if I agree with the result, the opinion did not put enough guardrails for the limits there.
For sure, because over 60 years there were no guardrails. The federal government could do anything. I mean, you look at
up to Lopez.
I forget the exact case, but it was up to like a specific. I'm pretty sure it was Lopez. Yeah. And by the way, Lopez was 5-4. So like, yeah,
well, they're hard questions. I mean, even I always mention Scalia because you say you're originalist, and I assume you like Scalia. You can tell me if I'm wrong. I assume that you think Scalia is base. I think Scalia is a super interesting guy, and I think that oftentimes when you agree with Scalia, it's like the best moment in like your law school when you're reading an opinion like Crawford or something, or the Kylo case, and you're like, and Scalia's on your side. So that's why I keep citing him, because I think a lot of originalists like him. But even Scalia said the Affordable Care Act case, it was a hard decision. What the Commerce Clause issue there, a hard decision, and that was a 5-4 decision. A lot of these Commerce Clause cases are. That's a super hard decision.
Sometimes children can be disappointed in their parents. Okay, it was not.
Well, you shouldn't be that disappointed. He came out against it.
I know. Like, I know. But like the fact that he was even a hard question, like, and by the way, Lopez is 1995, so it was roughly 60, maybe a little bit less than 60 years. Not good at math, that's why we're in law. That's why we do law.
So you think the war on drugs, the federal war on drugs, not the state war on drugs, the federal war on drugs is unconstitutional?
Yes. Yes. Yeah.
Not for individual rights, but as a powers question.
Yeah, and if we're gonna maintain Griswold, I think it's also unconstitutional on a personal rights issue. If we're gonna maintain Griswold,
because Griswold for you represents just do whatever the fuck you want all the time?
No, on Griswold to me represents a base. The reasoning given was, you're allowed to have progesterone tablets because we don't want the government kicking in your door and searching your room for progesterone tablets. Guys, and I mean, we're talking about like a drug that has like some intended effect. I don't see like a substantive constitutional difference between that and like maybe some other drug, maybe even a drug with like a medicinal use, right? So like, let's say you're having seizures and like you need like CBD oil or like marijuana in order to not have seizures, right? Even like you have something there, the federal government can still come in and like, jack your shit. And before weed was like really started becoming like mainstream, that happened a lot. the DEA would like come raid these poor, people with medical issues.
That's why I think the Gonzalez case is even better than the Filburn case. In the Gonzalez case, I think it's Raich versus Gonzalez or Gonzalez versus Raich. Clarence Thomas is in dissent in that case, where they're upholding the drug war as applied to a woman who grew weed only for her personal use. I think she had cancer. The litigants in that case were like specifically finding the most sympathetic litigant that they could possibly.
Yeah.
And so I hear you. What just happened is so beautiful, though. I want to put a point on it. Lactoid sees Griswold so differently than me. It's insane. Like we couldn't see Griswold any more differently. For Lactoid, as I'm understanding it, it's the right of someone to ingest a health product in the privacy of their own home and to limit government's reach into that home with respect to that use of the drug. That is totally different than how I see Griswold. How I see Griswold is the decision to bear or beget a child, family planning, intimate decisions of the family. And in some sense, that's irreconcilable. If he sees the case that way, then he's not going to see it my way. And then the drug example, from his perspective, makes total sense. If you're going to accept Griswold, you have to accept an individual right to drugs. That's why they don't agree with Griswold, because they don't agree that there is an individual right to drugs. But it helps you understand why we come differently on abortion as well. If you see abortion as in line with that decisional autonomy and the family planning stuff, then Roe just seems like the next step. Roe might be harder because the state's interest is different, and the state's interest, at the very least, he'll accept that Roe,
Yes.
At the very least, overturning Roe makes more sense than overturning Griswold, because in Roe the state's interest is way stronger than in Griswold. And if you were to like have a regulation banning condoms, so you might agree with him that as a way of just like, as a practical way of what do we overrule first, or what is most urgent to overrule, you overrule Roe because both has the shaky foundation according to him, and the state's interest by both parties is stronger in this case.
Yeah, no, that was completely correct analysis. So,
Oh boy.
Okay.
couldn't agree more.
So I was thank you. That was really interesting. I was interested in what you guys landed on previously with the rotation of the Earth. Because so the
That was great. He challenged me on that too. He wasn't going to let me go. He was going to tackle me on, is there anything in the Constitution that's stable using your interpretive philosophy? So, smart on him.
So the Earth's rotation is actually slowing down. It apparently it adds about like 1.8 milliseconds to a day every century. And in terms of like our actual calendar year, like scientists will add like a few seconds every so often to a year. So let's just say that it slowed down massively, and we had to add one full day to the calendar. For criminal sentences that are based on years, right? Should we should we just leave them be, or could the courts do anything about that in terms of like deciding how long a person can stay, or does it have to be a legislative action?
Yeah, I mean, what I would say is, if you're sentenced to 35 years and like let's say it slows down, you shouldn't get extra time because of the Earth slowing down, right? Like we should figure out exactly how much time, how many years, like how much time there is in the amount of years that you got, and that's the amount of time you get. Otherwise, you're gonna have some poor unlucky sap who gets extra prison time because the fucking rotation of the Earth slowed down. It seems a little bit unfair.
The corollary to that is that you shouldn't get less time if the Earth speeds up. Right.
Yes, very true, very true.
At some point, workability is important, and I think both me and Lactoid agree with that. There's this principle of not my Discord was talking about this earlier. By the way, Lactoid, all my Discord, there's a lot of like legal people there. They're all begging for you to join it, and they told me to publicly ask you because they want to like ask you a bunch of questions.
Will you join my server?
Yeah, I will, 100%.
Thanks.
But in that server, we were talking about the retroactivity principle of constitutional law, and that like when you release new watershed decisions, sometimes they don't even apply backwards in time in the criminal procedural context, and how disruptive it would be if like we applied the requirements of Miranda, which I assume, Lactoid, you think Miranda is pure legislation, right?
It might, yeah, it may be. I haven't fully analyzed that case, but I'm not seeing. Yeah, I don't know. I'll have to look into that.
So in that case, right, applying backwards in time Miranda to all the cases that have already been ruled upon and like undermining a crap ton of decisions is just unworkable. And the court's not, for prudential reasons, going to do it, even though legally that's what like you'd want, right? Legally, it doesn't make sense that people deprived of their rights earlier in time don't get the benefit of those rights just because by virtue they were arrested before the Supreme Court came to this ruling. Same thing, I think, with like this principle of the earth getting slower or faster. The court's just not going to get into like spending the effort to fucking calculate the percentage slowness of the earth and adjusting sentences every year between people. And I would say also, tying back in with stare decisis, there are prudential reasons why the court's not going to consider every year Marbury versus Madison, which Lactoid, I think he does say it's rightly decided. I assume because there's like a Federalist paper on point that says that was what was intended, but I don't know.
I forgot the Federalist Society propaganda that I got. It was some journal.
But I don't understand though, Lactoid. Like people will always bring up the point. Well, I don't want 9 justices deciding policy for the United States. If you have a problem with that, you have a problem with Marbury. Your problem isn't with Roe. Your problem is with who gets the last word on what the law is.
You're right. I'm okay with the interpretation, right? I just like when they're obviously contradicting, like at the time, like the intent, like what we know the intent to be. Like again, going back to the example with the 14th Amendment being drafted in the opposition to abortion, like it's just so obviously beyond the limits, and that's my opinion on that.
Yeah.
Quickly, NJ Palms, who gifted 20 subs previously, want me to tell you that Pisco is a beta from New Jersey. I need to get that out.
What?
He said that's in
I'm
chat.
not from New Jersey. I'm not a beta.
So making sure that
I've been to Atlantic City. That's it.
Okay. I want to make sure, guys, make sure to put your socials in my Twitch chat, including your servers or whatever. People want to join in. And NJ Palms is very amused. So he says,
all right.
I met from NJ. Like, I don't know. NJ, not New Jersey? What's NJ? NJ.
Oh, his name is NJ Palms.
Okay. Oh, you're a beta from NJ.
From NJ.
Okay. All right. Yeah. This is fantastic. Guys, we need to do this again. You guys like need to find something that you disagree on, and I'm sure you'll find a few things.
Shouldn't be hard.
Yeah.
But like, I really enjoyed this. It was a calm, respectful debate, and we learned something. I think everyone who was here who doesn't know, isn't legally minded, I think could walk away with a bit of knowledge here, and just a bit a more expansive understanding of how Roe v Wade, interacts with our society. So thank you all for this is amazing. So
is your Discord titled the Anti-Communist?
Yeah, Anti-Communism United. You can find me on Twitch and Discord.
Can I ask about the Lactoid name?
Oh boy, I get this question a lot.
Yeah, you do.
Because it seems to like bring into mind breast milk or like lactose or something. I don't know what that's about.
I think at this stage, I kind of want to keep it intentionally ambiguous. Maybe it does stand for breast milk. Maybe it doesn't. You guys will never know.
Okay. All right. So I'll send you guys off. I didn't actually plan on. Didn't even really look at who I'll send you guys off to. But I will send you off. I'm like quickly scrolling through here. I'm really important is streaming. So let's head over to him. He's a good guy. So
I'll do it too.
Yeah. I'll send you guys over to I'm really important. Guys, come back tomorrow. I'll be on I'll be on YouTube. I'll be doing a thing on YouTube, the streaming. It'll be fun. Come out to YouTube. Thursday we'll have all black everything, and people will continue on with our regular our regular stuff. So let me